Dollar store diva, she's holding it down. In thrift shop heels and vintage shine, looking like a million but all on a dime. She don't need a crown or gold to glean, fashion on a budget, living the dream. With every step she's turning heads, slaying the style without breaking the bread. Oh, Jamie, beauty queen on a dime, stealing hearts without spending a dime. Dollar store magic, she's the one to know, looking like a star on a budget low. Jamie, the talk of the town. Dollar store diva, she's holding it down. In thrift shop heels and vintage shine, looking like a million but all on a dime. She don't need a crown or gold to glean, fashion on a budget, living the dream. With every step she's turning heads, slaying the style without breaking the bread. Oh, Jamie, beauty queen on a dime, stealing hearts without spending a dime. Dollar store magic, she's the one to know, looking like a star on a budget low. She's got the plug, living like royalty, showing the love. Jamie, queen of style, making it look easy all the while. Beauty queen on a dime.
You are something else. What was
That was
that?
That's the wrong intro. That's the intro for tomorrow when Jamie will be hosting her first ever
Wow.
Beauty on a Budget stream.
My Lord, Baker.
What?
Oh my God, you kill me.
You said I should make an intro, so you were ready for
I did
tomorrow.
not. I did not. But guys, yeah, that was the first time I saw that. I was like, I walked away for a second and I was like, wait, is that my name? What is going on?
I don't know. You told
was
me
cute.
I'm not doing that Beauty on a Budget without my own stinger, so I made a stinger as told.
You are funny. You are so funny.
Yeah.
Hmm.
So tomorrow at noon, Beauty on a Budget with Jamie.
Monday at noon.
This new audio is really annoying me. It'll be better when I get my shelving in.
Yeah.
Hey, Debbie Blair, Virginia Little, yo, hola, Helen from
Guys.
Holland, an OnlyFan, and Jasmine, Venus Victor, Show Life Creations, Susan B. Womack, Gamer Ducko. No, yeah, well, it's an ad for Jamie's Beauty on a Budget.
Oh my
Hey,
Lord.
Danny G.
Hey, Danny.
And Suburb. Brokenhearted. Hello, I am fine. And Mrs. Crawford. Greetings from Massachusetts. Hello, kitten. And Teresa. Patty B. Mr. Brett. Jamie does make everything better. And I'm not funny. I know I am not that funny.
You are too.
Good morning, Queen. And JVH. And, of course, Mr. Peter A.
Hi, Peter.
Jamie, we owe people a stream.
Yes. They have to find
And
out.
Mommy and Daddy got mad at each other last time we watched it.
Well,
So, kids,
Mommy almost cheated too, and now I know the end result.
yeah, Mommy
So
cheated.
now
You heard it here. Mommy cheated.
I take back all of my arguments.
I love the increasingly complex schedule of big shows Jamie is hosting.
Yeah, my book
She only has
club
two
and-
shows. Beauty on a
You told
Budget and what was the one you got yesterday?
like book on a budget or something.
Yeah, your book club. Yes, that'll be
Yeah, you
Sundays
went in
at-
a chat and told people about it, and they actually were like asking for my link, and I was like, wait. This isn't real, guys. I don't think people understand Baker's sense of humor sometimes.
Tonight, after a movie night on Discord, Jamie will be hosting the first ever Books on a Budget, War and Peace, Crime and Punishment.
Yeah.
An intriguing story about a man who, well, no spoilers, but let's say he unalives his neighbor and what unfolds after that. Jamie will be trying to view it through a modern feminist angle to kind of try and make it into a context.
Stop being so serious. People are going to believe you. Don't believe him, everyone.
May. And watch your trials. Jamie is the host. No, Jamie isn't the host. Jamie is the owner. So
I'm just here to
I
make
work.
sure.
Jamie is just the one who, well, she told me if I start making more money, I could get a paycheck, but then she will sign them whenever that happens.
Yeah. That's about right, guys. I mean, it's fair, right?
Hell-raising angel. Been a second with the little kitty cat. Jamie without pregnancy pausing.
I still don't really know what that means. That phrase means exactly.
Take a pregnant pause. That's just to take a very deep pause where you think about stuff. It's not just like, oh, I'm going to smoke a cigarette and be back in 5 minutes. It's
Okay.
maybe I should think.
Really think about it.
Jamie's the landlord. Baker just works here. That's how it is.
Yeah, pretty much.
CNN, Jamie's news network.
JNN. I forgot about JNN.
Yes, put it on live chat so you get all the funny stuff. I will set my alarm for that, Jamie. Yeah, that'll be 2 a.m. our time. Well, no spoilers, Jess. Been a busy week, so I've been replay through for everything this week. Oh, well, now you're here. That's great. Jamie probably smells like a toasted marshmallow right now.
I do. I found some lotion and body spray that smells like smoky toasted marshmallow, sandalwood, and chocolate, guys, at Wally Mart.
That was David's segment.
There's my segment. Run and get it. It smells so good.
9-month pause. It could be.
9-month pause.
Gillet. And Reby from Australia. That's not an Australian accent. Please pass the pepper. Suitcase Sarah can't imagine being her cellmate. Well, she's in a duck, so she has 65 cellmates. Come for the lashes, stay for Baker's cuteness. Oh, Puddletown.
Oh.
Jamie, will you be doing Sarah's hair and makeup?
I really would if I could. I ain't joking. I'd be like, I'll volunteer.
You know you're going to hate me for making this, right?
Yeah, well, remember the eyelash video you did a while back? You played nonstop. So,
yeah, that was roughly a year ago too.
Yeah, so it's just an updated version. I'm good.
Well, let's get to it. We started out, we saw the first 14 minutes, and then we got a verdict, and then we didn't really get any further. So let's see how well it goes for Sarah. Jamie is of the opinion she didn't do it. Well, that's where we ended the last stream.
Well, you didn't really hear me fully, but we're not going to rehash. It's fine.
I actually rewatched her interview this morning on Crimes and Coffee, where she said, I left 2 fingers open.
Yeah.
She admits it so many times in that interview. It's so stupid.
What they're claiming now, sorry, I don't want to spoil everything, but what you're going to hear is going to negate everything she said and did. Like, it's just so stupid. Then she's gonna have to she's gonna have to explain herself.
Yeah. Sarah will put out. I have seen people alter her previous ad for a lawyer for a makeup and for a stylist.
Yeah.
They're pretty good, actually. They are all over Twitch. Accidental, non-intentional self-defense. No spoilers.
Hmm.
Whatever Jamie says is always right, even if I disagree.
Yeah.
That's the same because I'll get an email from HR saying, stop being rude to Jamie. Signed, Jamie.
Hey, I just like to ruffle your feathers and get you on. Like, I like to play devil's advocate sometimes. So,
Yeah, and I always treat you so nicely.
and you just scream at me. It's fine.
YouTube has been broken all morning, but this is working. I had because when I woke up this morning, I thought, what? Valhalla and Dave is still going? They weren't. So I tried to watch some of that Lego building, and that was really choppy.
It was chubby or choppy?
Choppy. Chuck.
Okay.
Couldn't get the feet to work. Hello. What are the chances the interview is thrown out? She was not under arrest at the time. Chances are slim to none. On a good day.
Yeah.
The rest of the time, absolutely no way. Even if she had been under arrest, Miranda rights is something you believe you have. Supreme Court have ruled that anything you say can and will be used against you, even if you weren't Miranda rights. So it doesn't work that way. Hey, Megan Florida. And Scott McGinnis. He's named
Hi,
after a
Scott.
beer.
Meaning of the death, which based on Peel is not something that falls under the ambit of a motion for particulars. So reliance on State v. Peel, understanding the age of.
Yeah, but that's because Vices and Aussie was building Legos, and when I opened, I just saw the thumbnail and thought, what? So I got a little confused.
This case as well. Understand there have been multiple lawyers who have filed responses denying the charges in their notices of appearance. Your motion is denied, looking at the totality of the circumstances.
Thank
you. Moving now to.
You have to go watch Fedorowski's video after this. It's about kitty cats.
Oh.
That's your
Cat
thing.
sanctuaries.
Well, that's the first view, Fedorowski.
Ooh, give me a moment. And I think we could probably address these collectively. The defense's motion for additional discovery filed September 2, and the defense's second motion for additional discovery filed September 6th. Similar to the first motion, the court has reviewed all the authorities and those motions. Mr. Owens, you may proceed, sir.
Can I approach the bench?
Yes.
And listening to his arguments,
Thanks, sir.
they're getting more and more wild.
Judge, we're going to handle these both collectively, and I believe we should. The first motion for additional discovery was filed on September the 2nd at 8:30, and then the second motion for additional discovery was filed on September the 6th. The first motion refers to the rule 3.220F for additional discovery. On a showing of materiality, the court may require such other discovery to the parties as justice may require. Specifically, the defense is requesting the Office of the State Attorney to provide a written policy of the Orange County Sheriff's Office relating to in-house interrogation procedures, in particular, the policy in place at the time of the interrogation of the defendant at the Orange County Sheriff's Office, which was back in February of 2020. And then the second motion for additional discovery Specifically, the defense requests the Office of the State Attorney to provide the standardized Miranda rights written policy, the form, and the card of the Orange County Sheriff's Office relating to Miranda rights form utilized and read directly to any suspect before any interrogation. Now, the argument by the state is well taken. The defense does have a duty to try to gather the information independently of the state attorney's office. And we did make a request to the Orange County Sheriff's Department back on September the 10th. And the request was for the written policies and procedures of the Orange County Sheriff's Office relating to the in-house interrogation procedures, in particular the policies and procedures in place in February of 2020. And the written policies number 2 and procedures of the Orange County Sheriff's regarding Miranda rights, written policy, the form and the card relating to Miranda rights utilized and read directly to the suspect before any interrogation in effect in February 2020. So as you know, Judge, I don't know if you've actually watched the 2-hour interrogation, but the day after this event, she was asked to come down to the Orange County Sheriff's Office under what my client believed was something other than an interrogation. When she got there, she was directed into a room. And I don't know, like you said, you haven't had a chance, but there are some serious issues about whether or not that was coerced, whether or not Miranda rights were fully read. I do not believe they were. I believe some of the statements that the lead detective said before she started the Miranda rights are coercive. She was in a room where she could not leave with 2 homicide detectives. One was wearing a firearm, and she acquiesced to authority based on an improper reading of Miranda. I wanted to file motions to that effect. We've got trial coming up October the 7th. I wanted to wait to get those policies. I wanted to wait to get the Miranda rights forms. The homicide detective actually reads it from a card. And I believe she read it incorrectly and she left out the main question at the end. So the proper thing to do is to get that information and make sure it's verified before you file in good faith a motion to suppress her statements. Well, the state attorney has tremendous power. I've made this request, September the 10th. Now it's, the 19th. And I'm in line with other public records requests there at the Orange County Sheriff's Department as to when I get this information. The state attorney could have gotten it the very next day if they would have made that request. That's why I filed the specific motion for the additional evidence. Time was of the essence. The court denied my motion on September 3rd to continue the case. We've got about 18 or 19 days left for trial. I'm still waiting. I've still got to receive that information. I've got to file the motion. I've got to set it for a hearing. I've got to subpoena
Most
the
of
2
them
detectives, the 2 homicide detectives. We've got to have a hearing with 18, 19 days left. I'm still waiting on this information from the sheriff. I've made a good faith attempt. Time is ticking. The state could get that information to me tomorrow. Thank you.
Response.
Your Honor, it's not Mr. Owens who's on trial, it's Sarah Boone. Sarah Boone was interviewed by the Orange County Sheriff's Office on February 24th and 25th of 2020. Now, some 4 years and 7 months later, there's this exigency not created by us, created by them. It's the defendant who has not done this for 4 years and 7 months. Now, turning to the merits of this, they are asking for discovery from a third party. Any discovery request, whether it is of the state or of a third party, has to involve allegations that this information is reasonably calculated to lead to admissible evidence or be pertinent to some analysis in this case. They have not stated why in their motion, and the arguments in
Yes, Black Swan hearing I will most likely cover tomorrow because we don't have any cases. Well, we might have one we're looking at, but we do have. Oh, I moved my, so I can't see it anymore. Let's. I moved my table half a meter to the right, so now I can't read my calendar on the wall. But we have 2 weeks till Sarah is supposed to start, so I'm looking at a case that might start Tuesday, but Black Swan will be tomorrow. My only problem is I'm building shelving units from IKEA on Tuesday, but Marissa can do it. She's always just doing nothing anyway.
You all right?
I don't know.
In court today do not state why it's pertinent either. The case law does not say statements are
Sorry,
inadmissible or only
Phoebe,
used for
but thank you for
impeachment
coming.
if the law enforcement officer violates policy. There's no case law that says statements are inadmissible or only used for impeachment purposes if they don't read from their Miranda card properly. What the case law states is
No, he just want more discovery, and the defense's state is up there saying why they believe that he shouldn't get it.
Mm.
statements are inadmissible if there are Miranda violations and only used for impeachment, or if statements are involuntary, basically through promises, then they can't be used for any reason. But nowhere in this analysis does it matter to any degree what a standard issued Miranda rights card looks like or what their policy is on interviewing. What they do have and what the defendant has had since February or April or whenever discovery went out in 2020 was a videotape of these interviews. There has been absolutely nothing stopping anybody from filing.
Yes, as I've been talking about, I removed my bed. That's why if it sounds a little weird, my audio, it's because I'm missing a bed with all the pillows in it so that it doesn't break up the audio as well. But I wanted more space behind me because those shelves are. I can't do it the opposite way. They're not that well secured, so I'm gonna get some new shelves. I have ordered it from IKEA. It's gonna be here Tuesday. So that's it. But no, I got way more space behind me now. So now I just have to figure out how to light the crap. Oh, my T-shirt I got from Little D. I'm happy when people give me gifts.
Where?
You can give me gift anywhere.
Oh, I mean, where's the shirt?
Hanging on the
Oh,
cabinet
gosh.
door.
I need a bigger screen. There we go. I see.
Yeah, you can just set up your computer Dave gave you.
I know. Now I got to get a camera, but it's fine. It's always something, I swear.
I need to put up an Amazon wish list for you.
I'm fine. I'll figure it out.
Exactly. It's only for you. I sleep on the floor now.
Yeah.
Well, yes, I can. And curbside pickup or leave off is it's not that expensive. I think I paid like $60 to have it delivered to my house. So it wasn't that bad. Because me driving in there, going back home, that's 90 kilometers. And you have to go find it. And it'll be, my car isn't really big enough to have it in there. So when I move to the US and get my truck, I can bring it home myself.
Get my
Brett,
truck in.
we don't ask those questions.
I mean,
You believe Pena is doing it?
also, I bet I could give Sarah Boone some nice beach waves with that haircut. Because a friend of mine used to have that haircut and they used to curl her hair all the time for it. Because it's so short, it's hard to do it herself. So I don't know. I can make her look spiffy.
You could make her look spiffy. Um, I don't know anything about Sweden other than they are way too close and they have been silent for too long. So I don't know if they're getting Americanized. Have to ask Pernille. Never seen an IKEA. Well, we have it. Yeah.
I've never been in one, so
Yeah, $20 delivery. That's cheap. I pay like $35 for delivery. They offer now that they can send a guy out to build it for you.
yeah. How much does that cost?
Well, the shelving unit I'm buying is 900 Danish a piece, so 125 bucks. And I think they wanted like 120 to build it per piece. So it's double the price.
Filing a motion to suppress if they believed under the case law, relief could be granted under the law. And the law does not have any analysis regarding standardized issued Miranda cards or policies of law enforcement agencies. And I don't believe that's admissible at trial either. If they did not violate the Constitution of the state of Florida or the United States in compelling an involuntary statement or by violating the dictates of Miranda versus Arizona, then questions about whether they read from their right standard card or if they violated policy should not be admitted in trial because it does not help the jury understand whether or not an element of the crime has been proven. It's not a part of the lengthy jury instruction now that we give about defendants' statements. There's nothing in there about, well, did they violate their Miranda card? Did they violate their policy? So first of all, the state's position is they have not asserted the materiality needed to get discovery ordered by this court, which would be reasonably calculated to lead to a.
Yeah, our IKEA isn't that big, but if I go out there, it's at least 45 minutes just to walk through it. And if you want to try stuff and go look for stuff, I took my gym buddy the other day, and driving to and from and going around there was like 2.5, 3 hours because it's, oh, I'm going to try this. Oh, this looks interesting. And it's easy an hour to get through in IKEA.
Evidence or to lead to it being found inadmissible by the court. And then secondly, it's on them to conduct this discovery, and coming in and saying that I can snap my fingers or not snap my fingers and get it for them instantly isn't evidence either. So it's our position that their request should be denied, primarily because it's immaterial, and then secondarily because it's on them. She's been aware of these statements since February 24th and February 25th of 2020. Thank you.
Thank you. Response to the materiality, please.
Well, Judge, I believe the prosecutor is wrong. One of the jury instructions, standard jury instruction in criminal cases said that essentially a statement has been placed before you that's made by the defendant. And I don't have the language here, but it should be weighed with great care and caution to make sure it was freely and voluntarily made. These are some, but not all of the circumstances that you should consider in deciding whether or not the statement that was made by the defendant was freely and voluntarily made. If you decide that it was not freely and voluntarily made, that evidence should not be considered by you in this cause. So even if we filed the motion, we got the information, the additional discovery that we need in good faith for me to file it, if we received the information, I typed up the motion, we had a hearing, the two detectives testified, and the court ruled that the statements were not suppressible, I could still bring those facts into the trial of how the mistakes that were made by this lead detective in the coercive statements that she made, as well as not giving the full Miranda rights form and getting a full consent from my client, that goes into evidence for the jury to decide whether or not to consider the statement at all. Thank you.
So where's the violation of the Constitution then? Assuming you're correct and assuming that the Miranda card, something was missing, what's the issue?
It's coarse. The statements that the lead detective, the female detective makes, there's 2 or 3 statements she makes.
Now you have to understand, I'm in a vacuum here because I haven't watched the video. I'm not asking you to play
I
it,
probably should have,
but I need a little bit more context as to these statements.
Yes, and just like the rest of Sweden, it's hell on earth, but you need to go there sometimes.
Mm.
Hey, the defense rests. Energy. But that's why it's, I don't know how much it is to get it delivered, but I never normally use delivery, but this time I said, nope, it's worth having it delivered to not go back to hell.
Because I have unfortunately no frame of
But
reference.
she says that, number one, the date of this event,
You wanted to say something?
they seized her phone at the scene.
Yeah, the judge didn't watch the video. He doesn't need to watch the video.
Yeah.
It's not.
I mean-
It's not his. He's not the one who's trying the case. He's just a judge.
Yeah, because they got to argue, make arguments, and he just goes off of that. He doesn't
Yeah.
have to see all of the evidence first.
But he should watch it.
She
It's
was
good.
told that they were going to bring her phone back to her, back at her apartment, the very next afternoon. The female detective called her, or Sarah called the female detective about the phone. The female detective said, I'm pregnant, I'm not feeling well, I don't want to drive out there to give you your phone. Would you please come to the sheriff's department so that we can give you your phone? Sarah Boone got there and saw that there was a desk or a place there to retrieve the items. And she saw the male detective and said, is this where I go to get the phone? He said, no, we got it back here in this room. Come back here in this room and we'll get it. When they walk back in there is when the video turns on, and now they're in the interrogation room. She's got a list. Sarah Boone has a list of things that she was wanting to ask them. And the female
course.
detective says, look, we got the autopsy
exceeded her.
back from the medical examiner. We've got to talk to you about that. 2 times she said, we must, I don't think it's must, we've got to talk to you. She goes, okay. So I got to read you these Miranda rights again. And
Again,
she had read them. There was a statement
There you go.
that
Again.
Sarah Boone gave.
Jamie, what does again mean?
Means again. It means you read them once and now you're reading them again.
But could it also mean have never read it to her, and that's why she was never Mirandaized the correct way?
No. Not if you
couldn't.
say
Oh.
again. No.
Oh, yeah. That part I didn't get. Well,
Mhm.
I know speaky English.
I just like that the judge said it to him.
Yeah.
Again? You
Yeah,
did it?
and the lawyer was just like, stupid argument.
Of course, she gave a general statement to the first deputy that responded to the scene. She was wearing a body cam, so that deputy had called the 2 homicide detectives, but it took them a while to get there. So she asked Sarah Boone what had happened, and Sarah explained that situation. After the detectives got there, they took a general statement from Sarah, but at some point they got into one of the squad cars. And I believe it was Sarah Boone. I believe it was the female detective and the male detective. And she was read Miranda rights, again, incorrectly, and she gave a statement. So now the next day, she's back in the interrogation room with the 2 deputies, the 2 detectives, and
Dave, if I voluntarily talk to the cops, do they have to stop me and say, sorry, everything you say now, I have to forget because I can't listen to you until I Mirandaized you? Or did you voluntarily give me information? As long as they didn't beat her and said, hey, talk about what you did, you scoundrel. That's
the lead detective says, we've got to talk to you about this autopsy. Giving her the impression that's what they were going to talk about. But I've got to read you these Miranda rights. And she said something, and Sarah said protocol, because they had told her in the first Miranda rights that this is just protocol. We have to do this before we speak to you. And she said, yes, protocol. So based on those statements that
Because it would be really, really stupid if you came to a crime scene and you said to the cops, I did it. And they said, oh, sorry, I have to read you your Miranda rights. I didn't do it. Nope. We have you on body cam saying you did it. Nope. I wasn't Mirandized. It's just a stupid argument.
we've got to talk. You have to talk to us. We've got the autopsy.
She was so hungover and had so much cotton mouth that she wanted to talk. She was trying to get that Dr. Pepper.
Yeah.
Rosalind, it's not Halloween till on 2 months. Relax. Not even Jamie has Halloween up.
Do I? Do you know
I
me
said
at
you-
all? It's been up
I said-
since September 1st.
Normally you have something in the background.
Well, not here. I don't have it in this room, but it's all in my
Oh.
living room.
Good morning, Laura.
Sarah to believe that they're going to talk about the autopsy. In addition, then she starts in the Miranda judge, she made a mistake on it. I don't know if it's an honest mistake, but in her probable cause statement, she said, I read the rights verbatim. The constitutional Miranda rights, I read to her verbatim. That is not true. Fortunately, we have it on audio. Fortunately, we have it on video. There is a legitimate question about whether that statement, that 2-hour interrogation, is admissible in this trial. That's what I'm going to show the court. I'd like to get their policy just to see.
What does the policy have to do if those statements were inadmissible? What does the policy have anything to do with that analysis?
To see if they,
Because if you're saying you have a deposition, I'm assuming it's a deposition of the female detective, said I read it verbatim, and you're telling,
that's in the probable cause statement.
okay, that it was read verbatim. Okay, excuse me.
Formulated the arrest report. It was a supplemental report or either the actual probable cause report.
And the representation in there is it was read verbatim.
That's
Now,
correct.
you've reviewed that interrogation. It's your position that it was not read verbatim. What does the policy have anything to do with that issue?
I think,
That's a simple constitutional issue, right?
yes.
If there's a case law that buttresses that position and that de facto is a violation of the Constitution, ergo, that confession or statements are not admissible because of the violation of the Constitution. What does the policy or the Miranda card have anything to do with anything if you have the video and the audio?
Well, the Miranda card is going to show that she actually omitted the last question. Okay? So the Miranda card is there for a reason. I don't know if they have them in the interrogation room or every deputy or homicide detective is issued that card, but it's a small card. But I believe it's going to say on there that you've got to get the waiver. There's 2 questions at the end, which is, did you understand the rights that I've just read to you? And the next question, understanding these rights, do you agree to speak with us now? That question was not read. It was omitted. I don't know why. She's sitting there reading it, and
Does the fact that that question was not read impact constitutionally under case law the admissibility of those statements?
I believe so, along
That doesn't
with
answer
her
my
other 2
question.
statements.
Respectfully, that doesn't answer my question. I understand what your belief is, but where's the case law that you can provide to the court?
I'm not ready for that, Judge.
Okay.
I'm going to file a motion to suppress, and I'll supply you with the case law, but I'm not ready for that. But the reason I wanted the policy, getting back to your first question, is because I'm sure the policy is going to say you don't make any pre-Miranda statements like, we've got to talk. We've got to talk about this autopsy. Those type statements are improper, that they're used to coerce somebody to talk. And I understand the detective, they had these videos, the 2-minute video and the short second video, and they had found it on her phone. So the homicide detective was chewing at the bit to get her to talk. So she was trying to induce or
Pernilla, I always listen to Jamie. I make so many altercations to this program just to make Jamie happy. Like when she asked me for a new stinger. I wouldn't have made that if she didn't tell me to do it.
Mhm.
ADHD in the making. Well, I'm not sure we have any Baker humor here. As I was told earlier, Jamie makes me funny.
Oh, whatever. Baker's a funny guy.
If the policy doesn't matter, the state could save the energy and just give it to Owens rather than fight. Yeah, give them the Miranda card. And
Yeah, like,
but again,
why don't they just shut him up and do it?
yeah, just say, hey, this is the card. Yeah, she left out the last word, but that's not against the Constitution. She chose voluntarily to talk. Yeah, they are not just there to help. They are not just your friends. Yeah, and police officers are allowed to lie to you. They are allowed to tell you, well, we're just going into this room to just brush off some details. Oh, by the way, we found some videos that's really interesting. It's not like your lawyer can try and do it, but I believe there has been certain rulings that it's fair for the police to lie. Altercations or alterations? That's the question. What's the word she uses when she says the corpus mentis? Right before that, she uses another word that's just wrong. She made up incentives or something like that.
She uses a lot of words out of context.
Yeah, and the Supreme Court has ruled that the cops can lie every way they want. Hey, Louis Cox. Because someone's trying to run the prosecutions in circle and make extra work for them, I liked when they told him, Sarah's on trial, not you. Yeah. Yeah, and again, the judge told him in the first hearing, you knew what you were getting into.
Mhm.
I never laugh. Hey,
Yes.
Anya. They ain't allowed to intentionally lie, but can I play something to make the perp believe a certain thing not allowed to be used to draw information? Hobby just said. Yeah, but if they're saying, hey, can I get my phone? Yeah, you just have to go into that room. That's not a lie. That's, and then say, we just have some questions we want to ask you. If you keep running your mouth instead of saying the magic words, je voudrais un lawyer. Don't, everything you say can and will be used against you. And Sarah
Zip it.
Boone is what is it called? A student.
Yeah, she's an A student. She's
Yeah.
won her spelling bee.
She excels at everything she does.
Yeah.
Caitlin just asked me if the Nickelodeon clip was real. Yes, it is.
I can't believe that. That's fine.
Yeah, I'm just burping heavily. That's why. No, there's a new clip out there where she's being introduced, and you can clearly see it's her. It's the same hair. It was just washed and fluffed a bit more.
Influence her to speak to them and to not exercise a fundamental right, not to speak to them without a lawyer being present. So she made those two statements preliminarily that I believe the policy is going to say you don't do.
Okay.
But she
Mr. J,
chose to.
anything else, sir?
Just, the Orange County Sheriff's Office doesn't set the policy for what is admissible evidence in court. The United States Supreme Court does, the Florida Supreme Court does, the 6 DCA courts do, and then ultimately, following their guidance, you will decide whether or not a statement is admissible in the state's case in chief, or if it's only available for impeachment. But whether or not
I found it.
Your partner there, Sarah, likes to hang out at the mall. Now, what do you do while you just
Oh,
Well, check out guys and spend money.
check out the dudes and spend the cash? Your cash or like parents' cash?
Mine.
Yeah.
oh my God.
When you that John and Sarah heading into the dog, they're gonna try to battle squash her. Hey, she's a hot cookie. She's tough. But
when I click on a particular file, there's a file inside of a file inside of a file. So when I try to open,
Yeah.
Check out dudes and spend money. Woo! Look where she ended
My
up now.
money.
Yeah. Could they do that? Where are they now? This is where
She's
she
so
ended up.
cool.
Oh my god. That was funny. Oh Lord. That's ridiculous. Oh.
Hanging at the mall.
Hanging at the mall, checking out dudes. Special money.
Could you imagine her straddling a bush in the food court?
Oh,
Hey fella, want to give me a Dr. Pepper? I can make your life better for a minute.
you have a great future. Oh my Lord. Oh, good one.
Yeah.
I know, Phoebe. Look how far she's come.
Yeah, and every 35 to 45-year-old American is sitting and thinking, "Oh, that was her." What do you like to do in the mall? Well, hanging out, looking at suitcases.
I think the suitcase store.
Since the last question is headed under waiver, is it actually part of Miranda? I don't understand that question. I don't understand.
Let's say hypothetically, she read the Miranda card 100% accurately. She followed policy 100% accurately. The state of Florida can't come in and say, Judge, I know they violated U.S. Supreme Court case law, but they followed the sheriff's office's policy, so these statements are clearly admissible. And the contrast is exactly the same. Whether or not they followed policy or read the Miranda card accurately has nothing to do with the analysis as to whether these statements are going to be admissible or only admissible for impeachment. And I don't believe that under the case law, they can come in if those statements are admissible and argue to the jury, they violated policy. They didn't review, they didn't read everything on their card. They violated. How does that help the jury decide whether or not the statement's voluntary? It doesn't matter what the policy is. It doesn't matter what the card is. What matters is whether or not they say the words that are required by the United States Supreme Court or the Florida Supreme Court or the 6 DCAs. That's what matters. That is what determines the bar for the admissibility in the case in chief or an impeachment.
Okay, thank you. All right, thank you both for your arguments and your positions. In reviewing the authority provided by the state, which the defense has conceded is taken in, is what it is. I think State versus Wright is the guiding light for the court here. 803 Southern 2nd 379. In reviewing that analysis, the defense has put forth an effort to do so. It's not up to the state to prove up anything for the defense. At this point in time, both motions for additional discovery are denied in accordance with State v. Wright.
Boom.
Moving now to the defense's motion to appoint forensic psychologist filed September 2, and defense's motion to appoint crime scene reconstructionist and death investigator filed September 2. I did receive JACS's response in that my judicial assistant confirmed.
Yes, it's a teaser for Jamie's new Beauty on a Budget show that'll air tomorrow at maybe the day after tomorrow on noon.
I love that it keeps changing.
First time catching alive. Owen is appeasing Boone with his winging. He and his team are a bunch of third-rate clowns. Only a circus act would respond to Boone's crazy ad. No, actually, I think what he's doing is he's trying to be this, an online grifter. Because I think he went around because he mentioned he was watching social media on YouTube. I bet you he would like to use this to be a stepping stone to get on court TV and become the new Emily D. Baker, because he thinks that's probably more fun than being in a courtroom with a horrible defendant. So I think that's why he's there. The other ones I don't get. But going from nothing to now having 2 paralegals, 2 lawyers, 3 lawyers, the amount of money being spent on this crazy woman right now that she will have to pay, which she can't because she's an alcoholic who has no money. I don't understand why they are doing it. If it's not for a book deal or fame, because they will get no money. I don't know how the rules are in the US, if the state will cover it and take it out of her pay like we do in Denmark. But there's no way in Sweden she can pay for all of these lawyers. Well, I'm disappointed that he brings in motions that he know doesn't have merit. Of course, he should do, and every defendant, even though I love Sarah Boone more than anything, every defendant always have the right to the best defense. I have stated multiple times when I find people are guilty of stuff when I don't think the state have proven it, that I don't think they proved it. My problem with him is he is bringing in motion he knows have no merit. I, a third-rate grifter from Denmark who has no legal basis, know that the policy for Mirandaizing someone has no merit, none at all. If he brought weighty discussions and motions that had some merit to them instead of just more of this, let's waste more time, I would applaud him. I still think he's a grifter trying to become the next EDB, but hats off for him for giving her the defense. I'm not going to make that $1 million, so I got to sue her after for damages. But still, it's probably not going to be as big of a catastrophe as it would have been because he's there. I just hope he's not trying to get out of it before trial when he finds out no money, no way the judge is going to do. He came in, he read the motion. The judge said there will be no delays, and he's now filing for delays. He volunteered to eat this can of worms, so he should not be complaining.
Confirmed that they are not asking to participate in this hearing.
Oh, your
And
president.
we did confirm that earlier this week.
No, he doesn't care about the law because he just filed motions that he clearly knows isn't lawful. Well, they're not against the law, but he knows Supreme Court have ruled you don't need to be Mirandaized.
Similar to the other motions that we've heard today,
Miranda.
I have reviewed them. Mr. Owens, you may proceed with anything else, sir.
Judge, I have filed the amended motion for declaration of indigency and payment of due process cost.
I did see that, sir.
And then there are 3 motions. I don't know if you got the third one.
Well, he's trying
Are you
constantly
referring to the motion to return property?
No,
And another time, if you think so much about the law, you also have to remember the second prong of a court case. There's, of course, the defense, but there's also getting justice for Jorge, who's not here anymore. This case have been pushed back 16 times. 4 years ago, almost 5 years ago, she was arrested. At what point does Jorge have a claim for justice? That's worth thinking about also, because we only see the people alive in a court case. We don't see those who are not alive. And many times, just so you can get to a murder case in 4 months or 6 months in another case. So this has been almost 5 years.
Relating to cost.
I don't know that I have. I'm just going by what the notice.
Yeah, but American Supreme Court doesn't agree. And the judge didn't agree. So I know the lawyer, you know, great respect for him. But again, we had a ruling, didn't fly.
Of hearing reflected. So no, I don't.
Well, he claimed when he came out of the courtroom after declaring he was pro bono that they had an agreement, so he was getting paid. Well, Medina Fenn, it's law. You know how it changes. They'll read you your rights, but they don't have to, because you voluntarily told them something. If you say, I want my lawyer, and they don't read your Miranda rights or anything, then maybe it had merit. But if you voluntarily go up to a cop and said, you have to come help me because I am so drunk and I just crashed into that car, those statements will be admissible in a court of law, even though he never Mirandaized you. Her previous lawyers will be paid out of the $15,000 money set aside for the JAC. So they will have to split those 15,000. One of them have waived his right to those money, and the three others will most likely get $5,000 each, that'll be the JAC that pays those. Yes, but he should also know when he took the case, the judge said, you don't get more time. So at what point is he just playing with the court? And at what point is he's not, because this court, if he hadn't shown up, we were going to court on the 7th, 9th, 11th of October. He knew it. He got on the job. It's not like you can get on a job and say, oh, by the way, I'm going to wait 2 months.
Filed a second amended notice of hearing. I don't know if you got that.
Was it forwarded to my office? Because if it wasn't, I don't know.
I'll have to ask Margaret. I don't know.
Okay.
But I filed a second amended notice of hearing. Can I
Please.
give you my copy?
And Mr. J, have you seen that, sir?
State doesn't have a dog in the fight with the expert witness.
Understood. Thank you.
Judge, what I had done
Don't
was
see
I
a date
had,
on here, Counselor. When was this sent? The certificate of services contains no date.
it was filed this afternoon, or
Okay.
this morning.
Okay. All right, what is the other motion related to cost, sir?
Well, there's one for the appointment of the forensic psychologist, Dr. Julie Harper, and it's non-pro-tunc. I'd like it to be retroactive to when I actually had to hire them. As you know, I came on the case late, I believe August the 30th.
Correct.
And then I asked Dr. Harper to go down and see Sarah Boone. Dr. Harper lives in Okaloosa County. And she came down to Orange County, I believe, the Thursday after we had the hearing on September the 3rd. I believe that's when the court denied my motion to continue. And so, as you know, we had to file the notice of intent to rely on battered spouse syndrome within 30 days prior to trial, which would have been that Saturday, I believe. So she went down, Dr. Harper went down and saw Sarah again. As you know, Dr. Harper had seen her several times early on in the case, back in 2020, maybe 2021. And so she had the most knowledge of, I believe, any of the experts that have evaluated Sarah Boone over the course of these 4.5 years. She was the one expert that had seen her the most. I asked her to go down again in the hopes that the court would appoint her. And she agreed. That was, I think, on a Thursday. She called me that morning, Friday morning, and said, yes, I do believe that she suffered from battered spouse syndrome at the time of this offense. Based on that, I filed the motion. But so she jumped ahead and did some work prematurely before she had been appointed. So I'm asking for those costs for her to do the earlier work, that be considered, as well as Dr.
No, you can be all the argumentative that you will. Just don't be rude, and I don't take you as rude. I'm way worse than you are. And you can be objective. I have been objective following this trial since last year, and I at some point would like to have justice for Jorge also. And it's just different opinions. And I know you can go all the way on the spectrum out there for YouTubers. I will grant, when we start the case, Sarah is innocent until proven guilty. I know some YouTubers is now claiming, well, she didn't do it, or she's innocent, or she should be left off because it's just an accident. You can get that. I am in a different place. I know Peter Triggers has a stand in the middle that she should be afforded another lawyer after her first fall, and that's the beauty. Different channels, different takes, and it's fine. I will fight for my position, and Peter will probably fight for his, and those people who think she's innocent, I don't know if they'll fight for their stance, because I don't really see wow. Well, enough about that. But always be argumentative, because if I can't defend my position, I shouldn't have my position.
Dr. Birkeland. Dr. Michael Birkeland is a crime scene reconstructionist and death investigator, and I'm asking for the court to consider paying for his fees as well as his transportation costs, as I have for Dr. Harper.
Jamie.
Again, to be retroactively to the time I asked him to be in work on the case. And then the last,
When was that? You're asking Nunc Pro Tunc to win on that, also to the August 30th date of your
Yes.
appearance?
if possible, yes. That's when I officially got on the case.
Now, as to the third motion for costs, I don't have a copy of that, unfortunately.
Can I approach?
Yes, please.
But you
Judge,
said,
I mentioned this
about another
expert,
fall.
Dr. Michael Brannon, in that hearing that I think we had on September the 3rd. He's a clinical psychologist. If you'll recall,
There's some YouTubers who take the stand that she may have been railroaded, and I haven't watched that content. I just know that they are Team Sarah. But again, there's also people who think that Karen Reed hit John O'Keefe with a car.
I'd mentioned him. He had served as an expert in the Marsha Thompson Palm Beach County case.
I recall.
And so, as you know, he serves a different role as a clinical psychologist. Dr. Harper is serving as a...
Oh, yeah, she deserves a defense. Well, she don't deserve a defense because she used her ways, and I think the judge's ruling was correct. But now she has a defense, and of course he should do whatever he can. But I just feel like he's filing motion he knows will lose.
forensic psychologist. And
do you know what JACS's opinion with regard to the motion to appoint clinical psychologist? Because the email that you attach as Exhibit A to that appears to be Mr. Lake's email regarding the other two motions regarding Dr. Harper and Dr. Birkeland. And it doesn't address Dr. Brannon, and notably JACS isn't here.
I don't have an answer for that. Maybe we could table this.
I think the state has, I'm assuming, no dog in this fight, similarly as they had with the other two.
The only request in this area that the state is going to make of the court is to, under its discretion under 3220, order these experts to produce written reports. We are on the eve of trial. I do not need one from Dr. Julie Hart.
I don't know what. Thank you, Mr. Meathook. I
Are
don't
you
know what
saying
you're replying to. I didn't see that, but I don't know.
What? Yeah. You said
Well,
some people, but you're not saying that they are.
yeah, I don't know. He has to file this motion. Well, he should also steer his client. We saw that in the Treehouse trial, where the attorneys tried to do one defense, and he said nope, and they said, well, then we can't morally represent him.
Her deposition is set October 1st.
Mhm.
These two other people, I have absolutely no idea what they are going to say, and we would, I'll file a written motion and a proposed order and send it to opposing counsel. But that's what the state's request is going to be on the other two experts.
Yeah, I don't know if I'm going to have an objection to a written report or not. I may, but I'd like to see what the motion says
Sure.
before
And
I make a
I'm not-
decision. But yes, Judge, we have scheduled Dr. Julie Harper's deposition at her office in Okaloosa County on Tuesday, October the 1st at 10:30 a.m. Eastern Standard Time.
Is that in person or is that virtual?
Central.
Is that in person or is that virtual?
I believe it.
Okay.
The state's flying in, and I'm going to be their judge. That's the county over from me, Santa Rosa County. So about an hour drive for me. So I'll be there in person. We're going to have probably Kevin Beck that's going to appear by Zoom.
All right, so here's what we're going to do. JACS has provided their response, and their response was not appended to the motions that were filed because that was prior to the amended motion seeking indigent costs that you filed, Counselor, on behalf of Ms. Boone. I'm going to hand file with the court now the September 9th correspondence from JACS reflecting that that can be utilized in lieu of a formal response. I'm going to grant your motion to appoint a forensic psychologist dated September 2, 2024, non-protunct those costs to August 30, 2024. And with regard to the other motion, the motion to appoint crime scene reconstructionist and death investigator, I will also grant that and appoint Dr. Michael Berglund, non-protunct, to August 30, 2024. With regard to the motion to appoint clinical psychologist, when was this motion filed? Similarly, the certificate of service does not reflect a date.
Let us check real quick, Judge.
Sure.
Give me a minute.
Yeah, you're good.
Again, like we saw in the Carly case, why haven't they filled out the paperwork correctly? There's two things now in this motion that he didn't have filed correctly. Again,
Yeah.
it's a small thing, but come on now. The judge is just going to get pissed on you, and it's going to hurt your defendant. For a long time. I can't even remember how long. Was it 4 years or something like that?
Excuse me.
I thought they were only together, like, they weren't even living together. They were just,
Well, they
on and
used to,
off for
but
like,
yeah, but she had a restraining order on him, but she let him
Yeah.
back all the time.
it was like 2 years, I want to say. Like,
While
just
you're
2 years
waiting on
back
that,
and
I
forth.
do see on your second amended notice of hearing, you also requested the amended motion for declaration of indigency and payments of due process costs also be heard. When was that motion filed as well, Mr. Owens?
It was filed just prior to filing these amended ones.
Were the-
It had to be filed prior to my motions for appointment of these experts.
1.5 to 2 years.
Give me a second.
I don't talk about my SMEX life, Daval. What's that question? Have I seen BDSM?
Okay, so the motion to appoint clinical psychologist regarding Dr. Brandon, excuse me, was filed yesterday. The amended motions regarding
think
Dr.
so.
Birkeland, an amended motion regarding Dr. Harper were filed yesterday, as was the amended motion for declaration of indigency and payment of due process.
Again, it's not so much like mommy and daddy got into a shouting match about Friday. It's not so much about the entering into the suitcase. That's not that important. What's important is she didn't let him out when he asked to do it. And she testified, I zipped the zipper. So that's the important. They could have all the kings in the world. It could be, I don't know, whatever you want to do. But still, even though you might like have a girlfriend who likes a little of the hand on the neck action, you're still not allowed to unalive her. You will be convicted, even though you said, well, she asked me to press harder. And she is stating voluntarily in the police interview, I zipped it up and I left 2 fingers open. And we hear her on video say, that's what you get for choking me. So it's not why he's in the suitcase isn't important. It's why he's not let out of the suitcase that's important.
Well,
Costs. That motion has not yet been granted. It is going to be. So the amended motion for declaration of indigency and
Yes,
payment of
this
due
is the
process costs is
double caveat.
granted. The amended motions regarding Dr. Birkeland and Dr. Harper are also granted non-protunct to August 30.
Brennan, isn't
With
it, Doc?
regard to the motion to appoint clinical psychologist filed 9/18, I'm going to ask Ms. Barrios, my judicial assistant, to forward that directly to Mr. Lake. And I know that she's watching this virtually.
A
If
lot
she's
of
able
them.
to do that now, I would greatly appreciate it.
But again, that's why you have safe words and all of that. Because even if it was consensual to start with, not stopping is not allowed.
See if we can get his response to that this afternoon, and maybe we'll be able to address that. It may be a similar vein as to the prior response that JACS had provided. Moving now to the motion for return of property, or in the
That's
alternative,
interesting.
motion for independent exam by the defense, filed September 18th. Similarly, with everything else, I've reviewed that and the authority, and I have reviewed.
Well, the safe word is always kumquat. So,
kumquat.
yeah.
Well, just wait, guys. This will all be thrown out the window. Eventually.
Jamie, no spoilers.
The state's
Just
response
wait.
to defendant's motion for return of property, or in the alternative, motion for independent exam by the defense. Mr. Owens, you may proceed, sir.
Judge, I believe the state's response is well taken. And I believe that what we need to do is get an expert of our own that can do the phone extraction and meet with the state attorney and the sheriff's department and extract the data, all the data that we need from her phone. So we would submit that the property should not be, based on the authority the state attorney has cited, the property should not be returned to the defendant since trial is still pending. But in the alternative, we're asking for an independent exam by the defense.
Response, if any?
As the state has stated in open court while she was pro se, that is absolutely fine. And I've even suggested a name.
Has the defense ever performed an evaluation of the phone? And the reason I ask this is there were prior experts that were appointed in the realm of electronic evidence.
Mr. Cacciatore may have the answer to that question. I don't, but I know that the state, as I stated in my response, we've never prevented anybody from doing that. And as the homicide supervisor, everybody in the unit knows how to go about doing this and allowing a digital forensics examiner hired by a defendant to go and work with the law enforcement team and get another imaging if they are not satisfied with the imaging that is provided.
Mr. Cacciatore,
Oh, yeah, I read this one. Have you heard about that Dr. Michael Birkeland?
No.
Well, he became quite famous in Dr. Michael Berglund is a former medical examiner who gained notoriety for a rather unusual and disturbing case. In 2012, he was arrested for storing human body parts in a rented storage unit in Pensacola, Florida. The remains included brains, heart, lungs, and other organs, which were found in over 100 containers. Berglund faces charges for improper storage of hazardous waste, keeping a public nuisance, and driving with a suspended license. I don't know what that has to do with anything. He was sentenced for 1 year of probation and 50 hours of community service after pleading no contest to charges related to the improper storage of human remains. He also faced a fine and was ordered to pay restitution for the cleanup cost. So,
This is her expert?
yeah, that's a medical expert.
Oh, Jesus.
That's, yeah.
What? He sounds like a good guy.
He
Why
sounds
did
like
he
a
have
winner.
Why is he storing body parts in a storage unit?
Jamie, why aren't you storing body parts in a storage unit?
Because that's gross.
Oh.
I'm not interested in that. Thank you very much.
I
can
think the
understand
issue
why
is
an
his
ME would.
license. That's yeah. He was sued for keeping human organs in a public storage locker, fired twice in 2 different states for not completing autopsy reports. Hasn't been licensed since 2010. Thank you, Gayla. He was just doing research. Jeez, guys. Yeah, he was doing all the extracurricular work.
Yeah, it's okay.
Afternoon, sir. Can you hear us? And if you can you announce your presence for the record, please?
There has not previously been a forensic exam of that phone by a previous defense counsel.
Okay. All right. Thank you very much, sir. There was a John Sawicki that was appointed back in, not appointed, authorized back in 2020.
Thank you, Stacey Murphy. Love your channel. I really wonder if Owen consulted with Sarah Boone before going all in with the... I haven't heard that. Everyone is giving spoilers about that self-defense. I haven't seen this. This is going to be a massive leap to make it with all the unintentional decorations. Stacey,
Sorry.
as I haven't seen it, I have a hard time. But yes, if she's claiming battered spouse, I know she talked about it earlier and they dismissed it because they couldn't get an expert to testify to it. But if she was so afraid, why wasn't it intentional then? Because if it's self-defense, yeah, you did it. It's going to be some stretch. I agree, but everyone stop spoiling it for me.
Yeah, I watched ahead. Baker did not, so he doesn't really know what the argument is going to be yet, guys. It's just me. But I didn't say what it was. I just said, just wait, everyone. Just wait.
Well, I think so. Stacey, it's a-okay. I could just have watched it earlier instead of going to bed. It's my fault, as always. Jim told me so.
You're fine.
As to electronic evidence. So I'm going to deny the motion for return of property based on the citations contained in the state's response. And I'll leave it up to you, Mr. Owens, to do what you need to do in order to have that review.
All right, I'm gonna do my best. We got about 18 days.
I'll cite to the parties for their own benefit. There were motions, specifically defendant's motion to appoint an electronic evidence expert and order the Justice Administrative Commission to pay costs. It was filed back on May 5, 2020. An amended motion.
Down underwear?
Wool underwear?
Well, you can get that.
No, but like, do you want to just like?
Well, maybe you like
sweat
that
down
scratchy.
there?
Would you like that scratchy feeling when you get sweaty?
Scratchy and sweaty?
I don't know. Jamie, whatever floats his
Your
boat.
choice. whatever floats your boat.
Yeah.
Motion was filed the next day, May 6th. Both of those cite to or refer to John Sawicki, Sawicki, electronic evidence expert. And there was a order entered back on August 3, 2020, appointing Mr. Sawicki as a forensic specialist. I have no idea if that order is still viable, but I'm just providing what the court file reflects in that regard. Lastly, that takes us to the notice of intent to rely on the defense of battered spouse syndrome. The original notice was filed September 6th. The state's original motion to strike was filed September 9.
Now we get to it.
Just to interrupt, I also have this defendant's motion for enlargement of time to address as well.
Yeah, I have that on my list, sir.
Okay.
Thank you. Thereafter, on the 15th, an amended notice of intent to rely on the defense of battered spouse syndrome was filed. On September 13th, the defense's response to the state's motion to strike defendant's notice of intent to rely on the defense of battered spouse syndrome was filed. And then I think it was this afternoon. Earlier today, the state's motion to strike defendant's amended notice of intent to rely on the defense of battered spouse syndrome was filed. The court has reviewed those and all of the citations contained therein. Mr. Owens, you may proceed, sir.
Let's go, Mr.
Judge,
Owens.
I wanted to start my argument, and then Mr. Henderson, who is on the screen, is going to respond to the state's pleading that they filed this afternoon.
Mr. J, you have any problem with that?
I know there's a rule in the circuit about one witness per one attorney. I don't know what the administrative rule says about arguments. I leave it to the discretion of the court.
Okay.
He's arguing that one motion that they filed this afternoon that I've been working on these. He was working on that motion, so it's a separate motion.
The motion to strike.
The last motion whatever motion they filed today, Mr. Henderson, Tony Henderson here in the screen wants to respond to that. I'm
Okay.
going to respond to the ones that were filed prior to today.
All right. I'll allow it. All right. Go ahead, sir.
Judge, as you know, I filed my notice of appearance on August the 30th, I think 38 days prior to trial, knowing that the court had already made a ruling that you would not grant a continuance unless there was some type of exceptional circumstance. And Sarah Boone hiring or retaining or somebody pro bono coming on the case and representing her did not constitute exceptional circumstance. And so, as you know, we had the hearing after I'd filed the notice on August 30th. We had the hearing on September 3rd on my motion to continue. The court denied it. At that time, I explained to the court that I believed after my meetings, I think I'd had 4 with Ms. Boone, that she met the criteria for battered woman syndrome, but that I needed an expert. And we were vetting several experts at the time, 4 or 5 that we were vetting, and we needed more time to essentially pick somebody to go out and do an evaluation, an assessment of Ms. Boone to determine whether or not they would give an opinion that she suffered from that. Because, and I understand, the court denied our motion, so that left us with, we still had to give notice to the state attorney 30 days prior to trial of October 7, which I believe was going to be September 7, which fell on a weekend, which was that Saturday, I believe. So we got out of the hearing. I think the hearing was on a Tuesday. We had 4 or 5 days to file this notice, to timely file the notice. So looking at the file, I realized that Dr. Harper had the most time with Sarah Boone. Early on in the case, I think when Mr. Padilla was handling the case, she was appointed by the court to do an assessment and evaluation. And so I reached out to her, and she agreed to come down a couple of days after we had that hearing, and she met with and assessed Ms. Boone. I've retrieved all the notes, the prior notes, and then the notes from that meeting. And then on Friday, I spoke with her, that Friday, which I believe was the date that I filed this notice, September the 6th. That Friday, I spoke with her on the phone, and immediately went down and filed the notice of intent to rely on the defense of battered spouse syndrome. We made allegations that Dr. Harper had formed the opinion that at the time of this offense, that Sarah Boone was suffering from battered spouse syndrome. And at that time, we gave the name of Dr. Julie Harper and her address where she could be found and located. And of course, the state has set her deposition for October 1. Now, the state has filed a motion to strike the notice of intent, alleging that we didn't give sufficient facts or evidence. But Judge, realized at the time, I was simply trying to get it filed because the last day was the next day, Saturday. And of course, I had just gotten discovery. Judge Creighton, we have not finished reviewing all the discovery in this case. I pretty much shut my law practice down to try to do it. I've gotten my staff, and we're trying diligently to go through all the discovery. At the same time, we realize that we've got to establish corroboration of the battered spouse syndrome from eyewitnesses, from medical records, from potentially neighbors, court records, her phone and the information on phone. So we're diligently trying, number one, to review all the discovery, which still has not been done. At the same time, trying to locate additional evidence that we could utilize in helping to establish the battered spouse syndrome. In addition, the state attorney yesterday filed a notice that they're amending their discovery, and all the jail phone calls, or I think they have the ability not only to call, but they have a tablet and they can text back and forth with third parties, that they have disclosed that they have, I guess, 4.5 years worth of communications between Sarah Boone and parties on the outside, and that some of that may be relevant to the case. And we were advised that when I got in town that I was to bring a CD, and I did this morning. I went to the state attorney's office and spoke with the secretary and explained to her that here's my CD, I'll wait. And I was willing to wait in the lobby to get this additional discovery when we have 19 days for trial. She told me that there was a lot, quite a bit of it, that she would try to get it to me after the hearing or by the time of the hearing. I said, okay. I left the CD. I told her she had my number. She could text me. I was staying at the Hilton across the street from the courthouse. As soon as she had it, I wanted it as soon as possible. A short time later, they have started, I guess, going through that material, and now they're sending discovery through email. I assume instead of the CD, they're going to do it that way. But we are receiving it. But just the volume of discovery that we have to begin with, we haven't gone through. The evidence we're trying to gather to corroborate our defense, and then additional discovery that we were noticed about yesterday. I didn't have time. I knew this had to be filed. I had one more day. As soon as Dr. Harper told me on that Friday, I knew I had until Saturday. I filed it. The state knew. They've had it 4.5 years. They prosecuted the victim in this case, George Torres, at least 3 times. I think there's more like 4 or 5 times. But they opened up a file. They prosecuted him here in this county for battery in violating the conditions of bond relating to staying away from Sarah Boone, but battery on Sarah Boone. They, if anybody, was well aware that there was a potential problem with the habitual nature in which Mr. Torres beat on my client.
But there's also a small problem that at least in 2 cases, Sarah is said to be kicking Mr. Torres.
Well, Sarah's
But she
done
wa-
the same thing.
Yeah, both of them have gone to prison for beating on each other. So, yeah.
In addition, my client expressed in the interrogation, which I know the court hasn't seen, please look at the videotape. Please look at my phone. Please look at the videotapes. Please look at the photographs. I need my phone to show you. He comes at me. It was ignored. They've had all this evidence. They had to be on notice
Well, I can't wait to see that
if
evidence.
this was a potential issue. And the reason being is all the lawyers that have been through this have appointed different forensic psychologists to assess her. The prosecutor that's not here today, that was here on September 3rd, when I mentioned the problems that we were going to have, getting an expert this quickly to form an opinion, said, oh, no, Judge, we're not prejudiced. We've already got an expert. We intend to rebut any said opinion by an expert that she suffers from battered spouse. We're ready to go. We've got our expert. Such that they said, we don't even need a continuance. If, in fact, he finds somebody and they file something, a notice of intent to rely on battered woman syndrome, within the time limits, we're ready to go. We don't need to continue it. We'll have our expert. And as you know, they're requesting that their expert now be allowed to go to the Orange County Jail and assess Ms. Boone, which they have every right to do, since we had filed this notice. But they indicated they would not be prejudiced. They indicated they were on notice. They didn't think it was going to happen 4.5 years, but it did. They knew all the prior abuse that Sarah Boone suffered at the hands of Mr. Torres.
I will be there for moral support if I can get my press pass before the trial starts. And I'll be there every day. Hopefully. Yeah, she didn't plead several times. No, she just said, I saw you guys frustrating me. They can just copy her phone. She doesn't need to show them anything. No, that's the thing. Why does she want her phone in her hand? I know why she wants her phone in her hand, because she thinks she can make it go magic bye-bye if she gets into her phone. The problem is she also knows they have the data dump. Everything on that phone has been downloaded because she has that in her evidence. She couldn't figure out how to open it, but everything is in her evidence because there's a magic little thing called Cellbrite, and it takes everything down. So exculpatory evidence, as we just saw in the Carney case, will also be in there if it's in there on the phone. It would be strange if Cellbrite just left out those videos where she said, he's coming at me. We are not having a wonderful evening. We were not doing puzzles. And I was sober. So, yeah. You actually like to hear this argument. Well, it's a good argument. It's not based in the reality we know, but I'm sorry that I stopped it now. Are they limited public seating at this trial? I don't think so. I haven't heard anything about it. It was just a joke. Is the Daniel only trial being streamed starts October 8 also? Don't know about that one, but Sarah Boone is my boo, so I'm going to do that. Well, she doesn't have my number. I didn't know her until I saw her straddling that bush and fell in love. Alkylex makes me think of all the smicks.
Alkylex. Oh my God, I can't with you.
Just realized it's autumn. I'm meal planning for the week while I listen. Well, Nina Canadian, make some pumpkin something.
Oh yeah, pumpkin spice everything right now. Oh, I just got some pumpkin spice wax melts for my little wax melters. I'm so excited. Stop it. Every time I talk about something.
It's just a teaser for tomorrow when you're going to do your show.
Well, in the middle of my work shift, yeah, that's where I'll be.
My girlfriend works at Samsonite. I can get a good discount if anyone needs some. Just saying, for camping, buy one within the next 10 minutes and get a free shovel.
Oh,
you need that.
Thank you, David.
Cellbrite is okay. They got lucky hiring some of the best form black bag forensics. I don't know black bag. Well, because I'm only funny online. And because I have a weird schedule where if I'm not streaming, I'm sleeping because I stream too late. I never meet anyone. I have more friends in America than I have in Denmark. Well, friends and friends, acquaintances.
I did the best I could, Judge. I filed it. I felt like I had to have an expert. I explained in general terms that she was psychologically and physically abused by Mr. Torres repeatedly over a period of time that led to this event. They filed their objections, which we believe is misplaced. The court, as you know, by that rule, let me find it. It's apparent not only that the state was on notice, that we were going to rely on it, it was prepared to respond and was not prejudiced in any way. The notice of intent to rely on the defense of battered spouse syndrome comports with the requirements outlined in 3.201, given the current circumstances of the case. And as you know from that rule, it says the notice shall contain a statement of particulars showing the nature of the defense, the defendant expects to prove, and the names and addresses of the witnesses by whom the defendant expects to show battered spouse syndrome, insofar as possible. Insofar as possible. I did the best I could, Judge. In addition, as soon as we started going through the discovery and gathering information about the prior events, the prior arrest of Mr. Torres, the prior prosecutions of Mr. Torres, we immediately amended the notice on September the 15th of intent to rely on the defense of battered spouse. And again, listed as many witnesses as we could based on the good faith belief that we had that corroborated either by witness testimony or physical evidence, photographs, videotapes, medical record, whatever we could find that would corroborate our defense. In addition, we've listed the ex-husband, Brian Boone, and the last paragraph, paragraph 14 says the defendant's investigation of evidence to support the defense of battered women syndrome is ongoing. The defense anticipates additional witnesses, photographs, videotape, medical records, court records, and other evidence gathered from the defendant's phone will be forthcoming. This evidence will be disclosed as it is discovered. Thank you.
Response, sir.
Judge, the state is not surprised by any of the evidence that has been in the discovery for years. I'm not going to belabor the facts in the discovery, but suffice it to say that the decedent and the defendant had a violent relationship, and generally this violence seems to be fueled by alcohol. We're completely aware of all of this domestic violence history, but that does not make a battered spouse syndrome defense any more than being mentally ill without showing more makes for an insanity defense. Their original notice was insufficient, and there's no reason to argue it since they've amended it. So turning to the amended notice, it still does not set forth what they are going to show that shows that she suffered from battered spouse syndrome. Was the decedent isolating her from her family and friends? Was he telling her that if she ever leaves him, he'll kill her? We have these instances of violence between the two of them. And when we get referred to the ex-husband, Brian Boone's deposition and statement, what he reports is that Sarah Boone would attack him, scratch him, punch him, and that she was a habitual alcoholic. And he would have to lay hands on her to restrain her. So we are going to potentially dive into all of this information in trial, but there are still the rules of evidence. And the cornerstone for...
Make that big. What do you... You are so ridiculous.
Why?
What is this? Oh my God, stop it.
Again,
Also,
that's when I fell in love with her. Those short shorts and those skinny, pale legs straddling a bush.
and then all you hear her as a child say, I like to hang out at the mall and check out dudes. She is a hoot.
She is a peach.
But do you hear what he's saying? Mr. Brian Boone talking about
Yeah, how she was
she's
the
gonna
aggressive one.
beat on him. Yeah.
Yeah,
So,
it's gonna be a
oh,
great.
Sarah.
Gonna be a great when they call him.
I know.
So you
I was
knew
thinking,
Jorge was attacking her. Yeah. And then the
yeah,
cross-examination. Did she ever attack you? Yep, multiple times.
yeah, she drank a lot. I was thinking the same thing, Sean. But last time I yelled at him about his bluegrass when he drew that or painted that one picture.
It's because apparently the green looks blue on screens. I don't know why.
Oh, okay. I'll give you that. You tried.
I did do it. Thank you, Jen Boogie.
For the battered spouse syndrome defense, which is a misnomer under the case law, because self-defense is defense, and battered spouse syndrome evidence is relevant to help a jury understand why it's objectively reasonable for a battered spouse to stay in a situation that puts them in fear of continued violence. The state and wherein our confusion lies is,
well, in the eyes of the law, every punch is an assault. So again, it's
Yeah.
But in front of a jury, did she ever attack you? Yes. That's just what the state is going to ask.
nowhere in any of the witnesses or any of the discovery that
He did, because Brian was actually going over there that morning to make sure she picked him up from school, because she apparently had a little bit of problem with the drinky poo. So she wasn't the most stable mom to pick him up from school.
that they have listed, exhibits that they don't even have been listed, medical records and so on and so forth. Nowhere does it set forth this cornerstone that is absolutely necessary before we get into any of this battered spouse syndrome evidence, before we get into any potential reputation for violence evidence of the victim, before we get into any potential specific acts of violence by the victim, before we get into the rebuttal evidence that is going to be offered against her for her violent nature and her drinking. The cornerstone is self-defense. Her statement to the police is not one of self-defense. It is one of accident. She repeatedly says there was no violence that day. So that is where the state's position is, that their notice is deficient. It only sets forth that there has been violence between the two of them, and it's apparently exclusively alcohol related. But it doesn't go on to say this violence has caused her to suffer from the syndrome. And here's why. She was afraid to go meet with her family. She was afraid to leave. She was any of the things that make up what is actually battered spouse syndrome. And moreover, it doesn't set forth the self-defense claim, which is the cornerstone of this. None of this comes in without a claim of self-defense. And so that's in part why we filed our motion in limine with that response, is the court can and should not allow any mention of battered spouse syndrome come in until self-defense has been established at trial. And as far as I can tell, the only person that can set forth a self-defense claim, since it was just her and the decedent in the apartment that night, is her. So she'll need to testify, and then she'll be impeached unless there's a ruling that the statements that she made to the Orange County Sheriff's Office are not only a violation of Miranda, but are involuntary and unavailable for impeachment use. That's what we're hoping to avoid, because we can't unring the bell during trial. If they put on all this testimony and evidence about battered spouse syndrome and about the past violence, and then we introduce evidence about her past violence against him and against Mr. Boone, it's hard to unring that bell. And even though King versus State, a 2000, I forget which year, 19 case allows the state to point out the things that are promised in a defendant's opening statement, but then don't come to fruition. That doesn't unring the bell. So that's what we're asking for. We're asking for sufficient notice. The statement of particulars that is required by the rule, where is it setting forth there is a self-defense claim, and then there is going to be this shown beyond just the past violence between the two of them. Thank you.
Judge,
He's court ordered to, and you can't get out of it just because she goes to prison. You'll have to. He's trying to get out of it. I don't know if it succeeded, but he was trying at some point to get out of it. He withheld payment when she went to prison, and Sarah Boone went to a judge to force him to pay. So it's court order. He can't do it.
Oh boy.
BSS, battered spouse syndrome. Yes, it's not BS. It's BSS. Jamie, I got all the backs for the giveaway painted up, and either I'll take a chance and send it to all the people who won, or I have to go make customs report for everything. It's going to take forever. I'm thinking I'm just going to try and ship it without declaring it to the customs, and hope it arrives.
Yeah.
Pernilla, did you make a custom report for the stuff you sent Jamie? Yeah, I mean, I believe she filed for it and won it. Yeah. Yeah, he seems less certain than the first hearing we saw, but who wouldn't? Because this judge has not. I think he came in and thought, well, the judge is going to give me 6 months, and they didn't.
they're scheduled to take the deposition of Dr. Harper October 1, so they're going to know fairly quickly what her opinion is.
What's your response to Wagner?
We're going to talk about Wagner, Judge, and I want to talk about that in a minute.
That's
But
family
he's
court.
bleeding the
That's
argument into
something
state's
special.
motion to strike the defendant's amended notice. And I would like for Mr. Henderson to respond to what he said about that. But Judge,
'Cause I agree, there's two different issues here. The first issue is the sufficiency of the notice, and whether the notice is sufficient under the rule. The second issue from the court's perspective, is it applicable? And that's the hang-up that I'm having.
that's not to be decided today. That's not Wagner, whether it's an accident or whether it's battered spouse and there was self-defense. That's not to be addressed today or not to be decided today. That's going to be based on the testimony from Ms. Boone about what was going on. But I'd like Mr. Henderson, if you don't,
But that's not what Wagner stands for. Wagner didn't allow, Wagner struck after multiple amendments, and the court, and we can take judicial notice of it if you want to, the court has pulled the file from the trial court in Wagner and has looked at the notices that were filed in that case for the battered spouse defense.
Judge,
The
but
issue,
ultimately, the female defendant in that case claimed that the firearm discharged accidentally.
correct.
And the court ruled, hey, you can't have it both ways. It can't be an accident and at the same time be intentional that you committed as self-defense because you're a battered spouse.
Right. So how is battered, even
It's premature for them to be arguing the question of intent.
But that's not what Wagner says. What Wagner specifically
specifically?
says, although the trial court found the third legally sufficient, the court granted the state's motion to strike the notice and precluded appellant from presenting the battered spouse syndrome evidence at trial. And the DCA says that the evidence underlying in that case was all accident. Specifically, the
Stop with this.
located.
I'm getting chubby.
Battered spouse syndrome as admissible where the defendant claims accident rather than self-defense.
We're not claiming accident.
But she has claimed that as Jess said, it was an accident. I went to bed and I came down and he was
It was
unalive.
not intentional. It was not intentional.
Yeah. So now they
So-
have to go in there and say, I intentionally sipped him into the suitcase to unalive him as a defense mechanism.
I think it's
That's
more
not going to
like,
fly
I
either.
think it's more going to be like, I didn't let him out because he just, I don't know. I don't know where he's going to go with this, but it's crazy.
Yeah, because as I'm not buying it, is saying he was sipped in there. Call the police. She used to do that all the time.
Yeah, she calls all the police all the time. Why not now?
Yeah.
Then what are you claiming?
Self-defense.
But every case that you cite, Medina, Hickman, its progeny, all pertain to some act by the accused. And that battered spouse is an excuse, a justification, an explanation for those actions. How is your purported defense applicable legally?
That's the reason we asked for the statement of particulars, Judge, so we could find out exactly what they were claiming that she did, what overt act or what omission. The overt act, was it zipping him into the suitcase?
But
Was that the overt
But
act
all of the-
that caused the
But all
death?
of the battered spouse syndrome cases talk about a defensive issue, not meaning defense, your side of the ledger issue. I mean, an action in defense. Wagner fired the gun. It was accidental. Hickman fired a gun. There was an act that was done by the victim or by the defendant in those cases. And battered spouse was used as an explanation for why it is that they did. How is that applicable to the case at
I
bar?
assume they're going to say she overtly zipped him up in the suitcase. I assume they're going to say he was asking to be let out of the suitcase and she refused. She failed in a duty to act. Later on, she went upstairs and fell asleep. So it's either an act or an omission, but they're claiming an act or a series of acts led to the death of Mr. Torres, which they have alleged was directly caused by Sarah Boone's actions or non-actions.
See, there you go. Battered spouse self-defense.
Hickman, the defendant stabbed the victim to death. And the justification was battered spouse. In Terry, which you provided to the court, Terry v. State, 467 Southern 2nd, 761, it was firearm. What's the
Mechanism?
I am actually not sure. Is he a criminal defense lawyer? Because apparently the ones Carly had didn't practice criminal defense normally. They're personal injury and something else. I would like to see his resume. How many court cases have he had in criminal court?
I thought you
Because,
looked it up.
What?
I thought you looked him up.
No, that was it this guy?
Yeah, it was this guy. Remember? 100
Oh yeah, he
trial?
was the guy. He was the guy that had a website that looked like it was written by AI
Yeah.
with his wife out there.
Yeah.
Yeah. But citing cases that all of them doesn't correlate with what you're claiming, that's just stupid. That's a great way to get your motion thrown out.
Mhm.
what is it?
They're the only ones that can answer that, Judge. That's why we asked for the statement
I
of
don't
particulars.
understand that circular logic. And the reason I don't is because it's your defense.
Okay. I'm assuming that they're claiming
Yes, go with this. Get manslaughter. Take a plea deal. Be out in 5 years. Online bet. This is what we've been saying the entire time. They were doing something, and she locked him in there after probably claim, well, I can still fit in a suitcase. Drunk people do stupid stuff. And when he got in there, she got mean because she's a mean drunk. And then she fell asleep because she was a drunk. Claim that it's manslaughter. No malice, no forethought. It'll be manslaughter. She'll plead it out for 5 years. Show remorse. Bingo, bango. Now she's going to go away for life.
That she zipped him up in the suitcase against his will, would not let him out of the suitcase, and therefore he suffocated. So the act of zipping him up and then the non-action of not letting him out when he asked to be let.
Yeah, that was the verdict he had. Not the verdict, the wording he had. I have taken over 100 cases to verdict where I said, but did you win or lose? Because 100 loss is still not good.
Out constituted the offense of second-degree murder. That's the only explanation that we can come up with based on the report, based on the evidence we have. But Judge, you remember Marsha Thompson, the Palm Beach County case?
But there was a firearm.
There was a firearm.
She discharged a firearm.
Remember Dr. Brannon said on the issue of imminent threat.
No, because they weren't going for a manslaughter plea. They have her on second degree unaliving. They have the videos. And she has claimed innocence. If she came and said, well, it was an effing accident, they would say, well, we're not going to waste $2 million on getting you prosecuted. 5 years in prison. See you later.
It is in the mind of the battered spouse woman.
Right there's the words. Imminent threat.
That's correct.
There was a threat. Now, I don't know all the cases. I don't know the facts and circumstances of that West Palm Beach case. I know snippets that you provided to me, but I haven't read any opinions on it. I don't know where it is on the DCA or appellate perspective, and trial court findings are not binding on another trial court. I mean, the case law is very, very clear on that.
Judge, the state doesn't know what happened the 2 minutes prior, or the minutes leading up to, the time leading up to the 2-minute video. The state doesn't know.
Not that we heard officially, but we know there has been communications about plea deals.
Know what happened after the 2-minute video. Only Sarah Boone can testify to that.
So you're going to bring her on the stand?
That's for her to testify to.
Gonna have to.
Yeah, now you have to.
Appellant has not cited, nor is our research located, any Florida case holding that evidence of battered spouse syndrome is admissible where the defendant claims accident rather than self-defense.
Who claims accident?
Are you claiming self-defense?
Yes.
Well, that's the first time that I've heard that.
Judge, I just mentioned it a while ago.
The word self-defense never came out of your mouth.
Nope.
Judge.
Words that you believe that the state's position is, what you believe that they're going to try to establish, that we don't know what happened before and after that video. The word self-defense have never been uttered this afternoon.
Judge, for the record, we're claiming
Pretty sure
self-defense.
he did. So
We're utilizing the battered spouse syndrome in conjunction with that defense.
Okay.
yeah.
Right.
Not accident, as they want to allege.
Okay.
So not accident.
Does your compatriot want to provide response?
I would have gone with accident.
further. Okay. Mr. Henderson, good afternoon, sir. Can you hear us? If you can hear me, sir, you need to unmute yourself.
Can you hear me now, Judge?
I can, but I have some concerns because I'm getting reverb from you.
I am trying to talk you to now. Are you able to hear me better?
I am.
Yeah, this
But
whole
it's
thing
my-
is messed up.
That we're hearing back again through your
I
microphone.
can just skip it.
I would just skip it. Yeah.
And that decision can only
So I think the arguments are better.
The court cannot make certain decisions. The court
I can't hear.
It's
Things that
terrible.
are, the jury, the defendant,
battered spouse. Now, if you don't get the expert to talk about battered spouse and render an expert opinion, battered spouse is out the window.
What?
So then you're just some self-defense at that time. But that argument and that decision can only be made after the evidence is within the trial. And that's all I have to say.
Mr. J, any response?
it sounds like we're largely on the same page.
Just shut up
The
and
one
sound,
point that I
Jesus.
would strongly disagree with is that this evidence of battered spouse syndrome is relevant to the subjective
Yeah, that got you
belief
right in the ear canal.
of the victim or the
Ouch.
defendant. That is not what evidence is used for. It's used to help a jury understand what an objectively reasonable person would do in those circumstances. And there's more cases that I have not cited because I didn't know that would be raised today, but they kicked out PTSD testimony just last year. I believe it's an Okendo, because it was going to the subjective beliefs of the defendant rather than helping the jury understand why an objectively reasonable person in a battered spouse syndrome would stay. With that notwithstanding, it appears we're on the same page that the jury should not be hearing anything about battered spouse until the predicates are laid. And from the state's position to help us prepare for trial, pleading should be sufficient. And it's still our position that the pleading was insufficient. The state is well aware of the past violence between the two of them, with her being the aggressor and the decedent being the aggressor. There's evidence of that all throughout the discovery. But what isn't present anywhere in the discovery and what left the state at a lapse in understanding this defense in particular was, did this violence cause her to suffer from battered spouse syndrome? And what is this evidence going to be? Was he isolating her? Was he keeping her away from family and friends? Was he psychologically breaking her down? Was he doing any of these things that are a component of the battered spouse syndrome? Because all we have is her statements, which are almost.
Remember, I've tried to say this a few times. You don't put anyone in a suitcase unless they are unalive. They're totally unalive, because you would have to break tendons and stuff like that. He got into the suitcase himself. I'm role
100%
playing this.
convinced. Yeah.
I'm gonna role play this. Hey. I remember back then, you be in that duffel bag. It was funny. Sarah, yeah, I can still fit in a suitcase. I don't believe you. I can still do it, Sarah. Should we try and put you in a suitcase? Yeah, it could be fun. Hey, I got Samsonite. And then he crawled in and she locked it up.
Yep.
And then she thought, that's funny. Now he's whining. Now I get evil. That's what I'm thinking happened.
I think she wanted to torture him. Like, not
Yeah.
just literally. I really don't believe that she thought he was going to pass away. I just really think she wanted to torture him. But now she's going into this, the self-defense thing. So now it's.
Yeah. That's
That's what I
stupid.
think really happened, is that they were drunk. He got
They were
in it.
drunk, they
She
were
was like, I'm
playing,
not going to let him out. And yeah.
Yeah, and she was just gonna say, I'm giving him a 10-minute timeout. Mommy's gonna go to the bed now.
Yep.
And she woke up at 1 p.m. the next morning and thought, whoopsie.
100 pages long to the sheriff's office, where she repeatedly says that night that nobody laid hands on one another. It was a great night. We were hanging out, drinking wine, doing puzzles, painting, dancing with the dog. And then, like everybody else, we were playing hide and seek. And
Jamie, how often do you dance with your dog?
Well, I dance around and my dogs hate it because they say, stop, lady, you look like a psychopath. But so I relate to Sarah on that one.
Come on, Rufus. Let's dance. Lady in red.
Lady in red.
And he got into the suitcase, and I accidentally went to sleep. And then she's shown her video. But her statements are all that it's an accident and that there was never any claim of violence that day between the two of them. So that's wherein the state's confusion lies. And I don't know how we're going to go about this at trial, if the defendant's going to have to testify in a narrative form, if she's going to come in and testify 100% differently than how she gave statements to law enforcement. But that's where we're at, is we don't want this in front of the jury until all of the requirements are met. And as far as I know, The only person that can say that it was a justifiable use of force that night is her, because it was only her and the decedent in the home that night. And thus far, she has not made any
Well,
statement.
now it was intentionally because now it's self-defense.
Yeah.
So now it's intentionally. That's the
See-
biggest, stupidest thing in this case because she will be played on video saying this was not intentional, this was an accident.
Yeah.
And that's what the
Crying.
judge said. There need to be a voluntary act of pewing or stab to use that defense. So she will have to testify to that. It's
Well,
it's
yeah.
gonna be stupid. It's gonna be so stupid.
And then he
because this-
alluded to you don't know what happened before the video or after the video, so she's gonna have to tell us what's going on if they want it
Yeah.
to. I mean,
and he just reiterated what she said. It was a good night.
About a justifiable use of force. And then our second complaint about the intent to rely on the syndrome, again, without repeating myself, is it just sets forth that there was past violence between the two of them, but no particulars about what actually makes up the rest of the syndrome. Thank you.
Any other final
Because self-defense is in the moment.
rebutting
It's not, oh,
offered in rebuttal to the
beat me
state's
5 years ago,
argument,
I'll
either
self-defense
Mr.
my way
Owens
out of it.
or Mr. Henderson?
Well, just, I'll
Yeah, he did say self-defense, but she claims it's an accident. To be self-defense, you must fear for your life in the moment you do it. You locking someone in a suitcase and falling asleep accidentally isn't self-defense. You can't accidentally self-defense yourself out of situation.
Yeah.
It's an act you do to defend yourself because you fear of your own life. And there was no clear and present danger when he was locked up in a suitcase. She could have called the police and let him out, and they could have let him out, taking him away. So
Yeah.
I can't see how she must have given him this line and said, "Put me on the stand. I can talk my way out of this." And he's just thinking, "Oh, I'm gonna buy a new 4K camera. Got a new computer coming in, so I can start covering cases." Didn't she claim she left a tiny bit of suitcase open? Two fingers.
Yeah.
So, and
So she
the
wasn't
police.
too scared then, was she? If she
Yeah.
thought he could get out, I mean, I don't know.
That's yeah. That's I don't know. Yeah. You call the police.
It's confusing.
Only thing that scares Sarah is a Dr. Pepper short. It's all not enough cheese.
Not enough cheese scares me too.
Well, you need your BCC. Yeah. Blood cheese content.
My blood cheese
let
content.
Mr. Henderson go, but just as it relates to Ms. Boone's testimony, that's what jury trials are for.
Mr. Henderson, any further arguments, sir? You're muted. You will have to unmute yourself. Mr. Henderson, you're still muted, sir.
Oh, Christ, this guy.
How can we be 5 years into the Zoom age and lawyers are the last people to learn how to do
I'm
it?
sorry. Can you hear me now?
Loud and clear, sir. Any other additional argument in
Yes.
rebuttal?
Clear, not loud and clear.
Yes, Judge.
Loud.
The state is going to have the opportunity to depose the expert, Ms. Harper, who can tie those things together. That's why we have experts who know about these things and who have the knowledge, who can tie these things together and tell why she's of the opinion that she was suffering from battered spouse at that time. The notice is simply to require to let them know that we're seeking this avenue and here are the witnesses that we're using to seek the avenue. We don't have to list a specific number of witnesses. It's just the ones that we intend to use. And as Ms. Owens has told you, this is an ongoing process and we'll probably be adding more. But that's all I have. Thank you.
All right. Thank you very
That
much.
was
The
a
court
great
is going to
argument.
take the issue under advisement and provide a written order. I'll endeavor to do that by the end of the week. Last is the defendant's motion for enlargement of time filed September 17th.
Enlargement.
Mr. J, have you had the opportunity to review that?
Yes, Your Honor.
Okay, all right. Any problems with proceeding with that this afternoon?
No, Your Honor.
Okay, very good. All right, I have reviewed that motion. Mr. Owens, you may proceed, sir.
Judge, and I do have about 2 or 3 other issues that we need to address, but yeah, I've asked for some time. I think there was an order. I know there was an order that you had.
And Officers Queen, have you met Sarah? She excels at everything she does. She's a straight A student. The only thing she never really got along with was Jorge's family. They called her everything but white woman. And I'm thinking, what's wrong with being called a white woman? You are white and a woman.
Yeah.
But apparently that's a derogatory term in Sarah's world.
Submitted to writing, and that was filed with the clerk's file that indicated that
Suitcase ninjas.
you wanted some things from the defense and from the state by certain dates. And I think that's a typo on paragraph 3. I said August 17. That should be September 17 on paragraph 3, Judge, of my defendant's motion for enlargement of time.
That says September 5 on paragraph 3.
Are you looking at my defendant's motion for enlargement of time?
Yes, sir. Paragraph 3 says Dr. Julie Harper met with defendant Sarah Boone on Thursday, September 5, 2024.
So he
looking at the wrong
Okay.
thing?
can't figure out his
I'm sorry.
own
I'm sorry. I
papers
was looking
again.
at the wrong one. If you look at the second page,
Yes, sir.
paragraph 7,
Yes.
that should be September 17.
Yeah, got it.
Okay.
I mean, obviously the court's order, the August 5 order speaks for itself.
Judge, and as you know, we came in late. Dr. Harper formed an opinion that week. We filed a notice of intent to rely on battered spouse. It's ongoing. That's all I can say. We're working, we're doing everything we can to uncover evidence consistent with our defense. The problem is it's 4.5 years ago, and the apartment complex in Winter Park has changed hands. So we're trying to run down the employees. We're trying to run down the other tenants of the place. We're trying to run down medical records. That office manager is critical. We've taken her deposition, but we can't find her. Brandon, I think it's Moats, the neighbor that lived right next door to Miss Boone and Mr. Torres, and they shared a wall, is a critical witness in the case. We're trying to locate him. As you know, 4.5 years, people move. So we need more time.
He's probably like, I'm
we're
out of
doing
here.
everything we can. We're working diligently. Billy Lane, the investigator, is working diligently to try to gather the information I'm asking him to gather. Coupled with the fact that we've got this phone that we're going to be extracting, I'm in hopes of in a few days. And I know that the state had extracted the phone and given us a lot of the data from the phone, but Ms. Boone says it's incomplete. That's the reason we want our own expert to extract it, that will be able to assist us in establishing evidence and testimony that she is a battered spouse and was a battered spouse prior to this event. But because of that, Judge, we haven't had time to complete that. And as I said in my motion for enlargement of time, we're asking to be flexible on some time limits up to and during the week of the trial, because we're going to be working that entire trial. Like I said, there's 18 days until trial starts. It's going to be a 2-week trial. I don't know when some of this information is going to come, but I assume every other day we'll probably be amending the discovery, the reciprocal discovery, and amending the notice of intent to rely on insanity or rely on battered spouse if we find other evidence that corroborates that. So we're just asking the court, and I know there's a rule that specifically, this rule 3.050, that allows for this request. Thank you.
Thank you very much. State, any response?
Certainly, the state is not going to be okay with them conducting their investigation once jeopardy has been attached. That is completely unfair to the state. This is the defendant's trial, not Mr. Owens' trial. She has been on notice of these charges since February 25th of 2020. She has gone through countless attorneys here who did not pursue this battered spouse syndrome defense, even though they had consulted with Dr. Harper back in 2020. And I believe the crux of that issue is going to revolve around her having to testify in the form of a narrative, given her prior statements. So the state opposes any enlargement in time. The defendant has been on notice and has had centuries probably of legal expertise at her disposal for the last 4 years. And there may come a point in time where the state has to request a continuance prior to trial, but if this enlargement is granted. But certainly, once jeopardy is attached, that's not the time to be doing discovery. She's had 4 years to do this, 4.5. Thank you.
Any other final arguments, Mr. Owens?
No, sir.
Okay. I'm just rereading the rule. Give me a moment.
Yeah, he's gonna file a motion somewhat time before court starts that she's insane. That's his next trip to try and get an enlargement.
Bye.
See you later.
Mr. Owens, as I stated when we had our hearing on September,
Jamie, I'm reporting your channel.
We can just report Haley's channel.
Yeah, I should report Haley's channel.
You really should.
Yeah. I normally don't block people. Should I do that?
Well, if they want to be a jerk, just whatever.
Yeah. Let's just say hide use on this channel. Bye-bye. Just have to see, did I forgot to put that you have to subscribe to comment.
Oh, yeah.
I don't know.
Whatever.
Well, I don't block people who have a different opinion, but people who want to report my channel. That's, again, everyone has their right to their own opinion, but just to say, I'm going to report this channel. I'm pretty sure there is a puddle of water. You go jump in that.
Yeah.
I didn't even express anything. I was drawing a suitcase ninja.
He was just minding his own business.
Yeah.
While
No,
we were
I
listening.
like a fun troll. I like when Nima stops by and say the same thing for 24 times. But
Yeah.
idiots like that, I don't care.
third, at that point in time, the court had outlined the history of the case, the court's prior findings, the numerous experts that had been retained throughout this case. And I understand the position that you find yourselves in. But at the same token, based on the same analysis that the court had relied upon in its oral pronouncement in denying your continuance on September the 3rd, I'm going to grant your motion and deny your motion in part. With regard to the filing of objections to the state's exhibits, by your own statement, you're still in the process of going through those. The deadline expired on September 17th. So I believe that we're using the second portion of the rule with regard to that issue because there was a requirement to provide those names, and this motion was filed on the 17th. So I'm going to grant your motion in part with regard to filing objections for the state's exhibits. I will give you up until the time that we're having our trial case management on September 26th to file any additional objections to any of the state's exhibits. With regard, however, to the filing of a witness and exhibit list, I agree with the state. We can't be amending once jeopardy attaches to provide additional experts or any witnesses at that point in time.
You're talking about jeopardy when the jury is sworn?
Correct.
On that Monday, October?
Nima was here Saturday. No, Friday.
Yeah.
Didn't say much, just said, hey, haven't seen you in a long time, missed you. So did we.
For 7?
If we're lucky enough to get one.
I am biased because everyone in the world is biased. But I try to listen to every side. I'll argue with everyone. Just see me and Jamie Friday. Daddy had to sleep on the couch that night.
No. Don't disagree.
on Monday?
I am
So,
biased.
Just so
Everyone's
that you
biased.
understand, I've ordered a couple hundred people for that week because I don't know how long jury selection is going to take. I don't know what people know about this case.
Judge,
So my intention is to run 50 people in the morning. So I'm just letting y'all full disclosure here, what my thoughts are. 50 people in the morning, get rid of language, get rid of cause. And if those persons who don't know anything about this case, I'm going to ask them to come back either Tuesday or Wednesday. And then we're going to run another 50 at 1:30. Get rid of our cause challenges, those who can't be here for 2 weeks, those who've just recently given birth, all the statutory cause reasons that they can't be here. I'm going to ask them to come back. And if we've
We won't be seating a jury before Wednesday, he believes.
Yeah, the judge thinks it'll be like 3 days at least. That's the very least.
Ugh.
got 40 people, 50 people at the end of Monday, we'll start Tuesday and we'll start whittling it down. And I can turn over when I'm done with my colloquy, my voir dire is about an hour and a half, 2 hours. And then I'll turn it over to the state and I'll turn it over to you and we can whittle it down from there. But if it takes us more time to get a sufficient panel because of the amount of time and other causes or preconceived notions about this case that can't be set aside, we may not be picking a final jury until Wednesday in this case.
is this set for 2 or 3 weeks?
2 weeks. 2 weeks. Now, it was originally set for 3 weeks. And then when we talked about it, when you came on board, we had shrunk that to 2. Now, if we think that that may change, I'd rather discuss that now than a week from now.
What? What did I do now? I don't know. And of course I'm pining for Sarah. She's a hottie.
You think we need 3 weeks? I can try my best to make that happen. But I respectfully need to know that sooner rather than later. Because in all candor, I don't know how long it's going to take us
I
to get a jury.
I did not anticipate. I anticipated we were going to be able to pick a jury in 1 day.
I would love to be that bullish. I hope we can. I'd love to be able.
Is he's thinking I'm gonna be out of here by Friday.
Yeah, it's
Yeah.
kind of funny. Like the amount of this trial in the media is crazy. Like I can't imagine it's going to be that easy.
We've seen crazy. It's again, we live in this world. How many people really live in this true crime world that we live in?
I know,
Not that many.
but you never know, especially in that area.
Yeah, and also it seems like he's surprised. He hasn't even checked the time schedule for this trial. That's, I don't know.
To. I'm just telling you what I've been working with jury services, that I've got 50 people teed up for 9 a.m. I got 50 people teed up for 1:30. And that will continue throughout the week. It's easier for me to say, we don't need you, go home. You don't need to show up for jury service than it is, I need bodies and we don't have them. Now, if we're able to get a jury in 1 day, fabulous. But if we can't, I have that backup.
Hey, my cozy cat.
I believe
That's not what it says.
if we pick the jury in 1 day, we could try the case in 2 weeks.
I
But
saw
if
the
it's gonna
dog
take a
and
little bit
thought,
longer.
cozy cat?
And again, we don't know from now until October 7th what other evidence or what other witnesses we're going to uncover. So in the abundance of caution, I'm going to ask the court, if possible, to set 3 weeks.
No, I've been attached to her since she said everyone covering this case is going to be a millionaire.
I don't think it's going to take 3 weeks, but I don't know how long.
You don't time limit trials. You say this will go for about 4 days. And then you see, they'll do the same here. They'll say, okay, this is probably going to last 3 weeks, 2 weeks, because we have this amount of witnesses, we have this amount of evidence. It'll be roughly 3 weeks, 2 weeks, whatever. And then you get through the first week and the defense is saying, we can't do it. We saw that in what trial were we watching where the defense was so slow and the judge got angry at them?
I feel like that's every trial.
No, it's the state. It was the state. Was the Mew case that they couldn't get through because they called so many witnesses and I think the Mew case, they kept asking for days and said, we'll be done by Wednesday, we'll be done by Thursday, Friday will be done. And I believe it was the Mew case, maybe. So yes, you have a time limit, but it's not a time limit. It's also because the lawyers will have to slot in and say, okay, for these 3 weeks, I can't do any other trials. So you have an expected time limit.
On jury selection is going to be, I don't know what additional evidence. We're going to uncover additional witnesses from now until October 7th. So to be on the safe side, I would ask for 3.
Okay, all right. I'll see what I can do there, and I'll have Anita
Maybe
report
it was
back
the
to
vice
both of you.
file, yes.
Judge, and the main reason, I think all these other lawyers, they didn't have an expert that had tendered that opinion about her spouse. So we started on this path on that Friday when Dr. Harper called me and I filed the notice of intent to seek corroborative.
The most important people in this case that everybody seems to have forgotten in this room is the jury. So we're going to take a 15-minute break and both sides take a pregnant pause and think about the jury.
He did, with good reason.
Get it.
I think that's because it was a civil proceeding, because again, can you limit the defense and say, well, you have 2 days to do your defense? Yeah, but we're going to bring in 500 witnesses. No, they'll be turned over on appeal.
Evidence, corroborative witnesses that she was battered. So that didn't really start until.
No, Murdoch was, there was no, they just turned a murder case into 4 weeks of accounting.
Yeah,
That
but I
day,
kinda
which was
see
September
where she's
6th.
coming from.
And that's why, and again, this was an event that occurred 4.5 years ago. Trying to locate witnesses is
No
just taking
spoilers.
time. I understand about the jury being sworn and we shouldn't
But I
be
would like a
allowed to
microphone on the
ask
bell.
additional witnesses coming. So I agree with the state on that. I agree with the court. But I would ask up until the time we pick the jury that we be allowed to amend reciprocal discovery and amend our notice of intent to add additional witnesses and additional evidence.
Mr. J, any other further positions, sir?
There just may come a point in time, Judge, if you don't set a deadline that the state has to ask for continuance.
The deadline is going to be for objections to the state's evidence, providing of a witness and exhibit list for the defense at trial case management next week, September 26th at 9 a.m., in addition to all the reasons that the court placed on the record on September 3rd during the motion to continue. My JA has advised that Mr. Lake has appeared virtually with regard to the motion to appoint clinical psychologist. Mr. Lake, can you hear me?
Yes, I can, Your Honor.
Can I get your appearance for the record, please?
Yes, Christian Lake on behalf of the Justice Administrative Commission.
All right, thank you, sir. Earlier today, before your participation, I know that Mr. Owens had provided you certain cost motions regarding the forensic psychologist, Dr. Harper, and the crime scene investigator, Dr. Birkland. You had advised as the JACS's positions on those motions. Your email has been filed in the court file. Subsequent to that, a motion to appoint clinical psychologist regarding Dr. Michael Brannon was filed. That was just filed yesterday. I know my judicial assistant sent you a copy of it. Have you had the opportunity to review that motion? And if so, what is JACS's position?
Your Honor, just briefly, we did review the motion. Although we're not contesting it beyond objecting, we do object to any rate in excess of the rates established by law. But we acknowledge for this type of expert, it would not be uncommon to approve a rate of $200 an hour. It's if that does exceed the rates established for this circuit.
Mr. Lake, I hate to interrupt you, sir. Madam Court Reporter's having a difficult time hearing you. If you could start over and slow down just a smidge for us, we would greatly appreciate it.
Not a problem, Your Honor. We did review the motion to appoint the expert. Just to give the court some background, because I went back and looked through our files. So far, the defense has incurred, this is prior to Mr. Owens' involvement, but so far the defense had previously incurred $7,500 for one mental health expert, and that's the same mental health expert as being, not this expert, but was the other expert being requested, was requested by the defense in the other two motions. The defense also incurred $1,800 for a mental health expert that was hired by Ms. Cashman. That was let me just get the right name, I don't want to say the wrong name, but she was paid $1,800. She was retained in relation to the issue that was before the court today, the battered spouse syndrome. And now the defense is requesting a third mental health, but also at the rate of $200 an hour. Based on the nature of the case, Your Honor, we have no real, other than objecting to the rate because it does exceed for the circuit. We don't have any other concerns about the appointment of the expert. It would be the third mental health expert appointed to assist.
Yeah, Kitty, it's just because we are online snoops who live a life of true crime. We remember these cases because it's the crazy ones. It'll hit the newspaper the day before and nothing else.
Defense, but that really, I mean,
What I gathered from this was they already paid for one expert $1,000 to test the battered spouse syndrome, but he wasn't opposed to paying for one more.
ultimately that's your call whether to allow the defense to incur costs for a third mental health expert.
What are, the motion reflects the rate is $200 per hour. Is that in excess of the JACS rate?
Your Honor, to the extent of the rates for the circuit, those were the rates that were adopted back in by the old Immigrant Services Committee back in 2007. We essentially generally don't ask for a hearing unless the rate is over $200 an hour. So we generally, again, we acknowledge that is, the rates generally range for mental health experts range between $150 to $200 an hour. So we don't particularly object to them. As far as what the rates were at that time, they are posted on our website, and I'm pulling them up right now because for the Ninth Circuit, the rates for medical doctors and psychologists are $160 an hour for out-of-court services and $178 an hour for in-court services.
State anything further?
Nothing on this.
Okay, all right. The court is going to grant the motion to appoint Dr. Brannon. I know that the state advised that this is not going
I don't know, but I need 7 chili cheese chops.
to be
At
done
McDonald's?
because I've received nothing from you, Mr. Owens, that he's done any
They don't
work
sell
yet.
chili and cheese
Okay,
dogs.
so this will be effective as of
Chops.
today, the 17th of
Cheesy
February.
puffs. What do you call them? Chili puffs.
September.
What? I don't know.
Yeah.
You know these little deep fried cheese balls with chili in it.
We
Chili
don't have that in our
jalapeno.
McDonald's.
Jalapeno. We talked about this before, Jamie. You
Oh, is
just
this
called it by.
your McDonald's?
Yeah, I don't go to yours.
Well, I'm just saying, like, you probably have different stuff than us.
Yeah, but it's a small fried ball of cheese with jalapeno bits in it.
Sounds
It's
good.
the perfect driving home food from McDonald's while you wait to eat. Jalapeno poppers, that's what you call them, yeah.
Yeah.
Hey, Laura.
Hey, Laura.
It's they're good. Just for the ride home from McDonald's.
Is that not what I just said? I'm sorry if I said a different date.
Pickle beer.
I will take it under advisement, the issues pertaining to the battered spouse syndrome, and provide a written order. You had advised there were some other issues that you wanted to bring up, sir.
I know. You don't.
They're good. You should. It's cheese with jalapenos in it, Jamie.
Yeah. I pick the jalapeno out. I just like the juice and then I eat it. It's very good.
This relates to the investigator, Billy Lane, who's working with the defense and his potential costs up
Pepperoni
to
juice.
the trial.
Are these being?
A beer with no seasoning. You don't. A beer should taste like a beer.
Jamie gave me a
We're
beer with no
never
seasoning.
ever gonna
Well,
meet
Justin.
up and drink a beer.
First of all, I've never given you a beer. Iris. Can't with you. Nope. That's never happened. I don't know what you're talking about.
A beer with a friend in a hole in the wall local place sounds great in Denmark. Well, my local hole in the wall I got thrown out of as a kid because we were playing darts and I always hit the lamp above the dartboard, so I never go there. But I can take you to.
Oh, I forgot about the beers on the way to the game. They were just,
Yeah.
they were Bud Lights. So the worst ever.
Oh yeah. Then she didn't give you beer; she gave you Bud Light.
Yeah, it was all my sister had. So can't be picky.
Well, I like to go to a place called. Do you call it cabins? The things you're sleeping in a ship. Yeah, it's called cabins, right?
Yeah.
Yeah, we have a bar called that. It's a good place. It's become a little too young now, but they have karaoke and you can play dice and it's a good place. Beer's cheap. I'm gonna meet Iris down there. Give her a beer with some flavor.
Yeah.
Hand filed now?
Mr. Lane handed them to me right before we came in, so I'm going to have to scan these in and file
Best
them.
place in the world.
Okay.
I wanted the court to be aware. If you want to address it at the September 26th case management conference, we can do it then.
Let's do that. Just do me a favor if you could, sir. Once they're filed, just forward them to Ms.
That's why trying to kill Iris with the garage door was self-defense.
Yeah.
Barrios.
That's
Okay,
still
so
the funniest thing
I've got
ever.
hard copies of them.
All right, I'll do
I'll
that.
give these back to you, sir.
Judge, the other thing was, of course, we've got trial coming up quickly, and generally,
Yeah, because we got a warning said, please stop hitting the light. And then I was a little drunk. So I can't go there
when
anymore.
in a courtroom, I do opening statement, I maybe have some demonstrative aids, but I walk around, and I understand
It was-
here that we've got
It
to
was
be in
when
front
she
of the
got to my
microphones. Is there
house,
any way we can
immediately
set
I
up
tried to
maybe-
I tried to offer. It was the first day she showed up. Oops. Oops.
You didn't like having guests, so
I
that's
know.
the way
I was
to do
like,
it.
oh,
The defense can set up
well,
Yeah, well,
if I can get her out of here real quick. No, I'm
system
kidding.
where we can wear a mic so that we can walk to some degree.
I will have to check with court admin.
All right. And then the other thing is, we would like Sarah to wear street clothes.
so she's going to be street like me?
Yeah, she wants her street clothes.
Oh, that's gonna
We
be
should
cool.
suggest curry yellow.
Curry
like
yellow
curly-
super pants,
Those little Junko jeans.
Junko jeans, and a FUBA hoodie.
So do I need
So,
to file something?
I have, get in touch with the public defender's office. When Ms. Boone was representing herself, I had coordinated and communicated with the public defender's office multiple times in an attempt to obtain clothing. Before you came on board, Mr. Owens, Barry Click, BARRIECLICK, had provided the
She should have a
total amount
tiara.
of clothing that they had that would fit Miss Boone, including shirts, pants, slacks, skirts. And that was the time where she would be allowed free reign and was going to have the shock device on her lower leg. I would ask that you can email Miss Click. You can find her information on the Florida Bar webpage. And ask
Right.
her if the public defender would assist you in providing clothing. They were going to while Ms. Boone was representing herself, and I imagine that offer would still be extended.
Judge, and I anticipate 2 more pretrial hearings. One is the case management
Why?
conference, and 2, if I file a
Terrible.
motion to suppress the statement made during the interrogation, we would
Psychable.
probably have to set a separate date.
Oh.
Can she wear street clothes at those
Just
2
use
hearings?
Bill.
If you could get it to her.
Yeah,
So that's something you have to
She wants a ninja outfit and one of those puff bombs they have in the movies, so she can escape.
work with corrections. I don't know that they're going to let you do that.
Now, when it comes time to trial, we would like, she would like for us to have some makeup for her and somebody to fix her hair in a way that's presentable to the jury that she would like to be presented. Do I need to file a motion on that, or?
I think you're going to have to.
Okay.
wants someone to do her hair.
I believe that's all I have, Judge.
Okay, all
Yeah.
right. Anything else, State, we need to address? All right, anything else, Mr. Owens, or from your co-counsel?
No, Judge.
Okay,
Somebody
I
to
will
do her
see you
makeup and
all
her
on
hair.
September 26th at 9 o'clock in the morning, and I will endeavor to get you a ruling on the battered spouse issue as soon as practical.
Well, Jamie, that was an absolutely
I
disastrous.
would love to, Sarah. I would love to.
And Brandon, yes, she got me working also on a Sunday.
Mm.
Jamie to do her makeup on a budget. Yeah, call JAC and say Jamie will do it for a plane ticket and $50 an hour.
And me and Sarah can gossip. It'll be fun.
Yeah, and you can sit there and say, oh, what kind of suitcase? And then he'll call me back and say, oh, it wasn't a Samsonite. It was I don't know.
You know, you say, you like going to the mall and checking out dudes? I was. Let's talk
Yeah, I
about
want someone to do my makeup as well.
that.
Give me a hair. Yeah, again, we just saw Laurie Shaver with the most 90s eyebrow you could have in the world. And she did her own makeup.
Mhm.
Is Brandon now a disregarded entity? No, Brandon's Brandon. He's just been out on vacation for a couple of weeks. And did you watch the Formula One today? Absolutely crap show again. And you can sit on the beach on your off days.
Mm,
Jamie is not
as
much of a
long,
beach goer. You can go
as
visit Little
long as
D.
the temperature is
Well, that's
at a
probably
good.
a problem now.
I mean, October, I don't know how hot it is usually in Florida. I'm not a hot person, guys. I love the fall. I love the winter. Like, I like winter. I like fall. I like spring. Summer can kick rocks.
Yeah, that's but you can stay with Little D. I don't know. Florida can't be that big. It's right next to each other.
It is actually pretty big.
Oh. Yeah, she smacks it up her hair when JJJ was on the stand. That was such a tell when all of a sudden she had straight hair and had highlights in it. But then she looked good on her mugshots because she was taken to prison. 10 months of dry Danish humor and a lot of moist o'clock.
Oh, God. Come on, Danny.
Thank you, Danny, for being a member for 10 months. Jamie, that'll be that for today. Can you
Good.
remind people what they should do tonight? Oh, this afternoon.
It's movie night in the Discord. So everybody join the Discord.
And
Come
we
hang
will
out
be
with us.
watching
Predator at 4 p.m. Eastern Time.
Predator at 4 p.m. Eastern Time. The greatest
Yes.
movie ever made after The Barbarians. That's
Barbarians movie. I still haven't seen it. I missed it that day. But
it's the greatest movie ever made.
I highly doubt that. But
Uh,
that's adorable.
Thank you, Christy G. 3 months. Love it here. Best place on the YouTubes. Well, it's slightly above some places.
Yeah.
I'm not buying it with a super sticker of a wow love face. Is that a baby showing a butt? Is it? We don't condone that kind. I want my baby butt shown. Baby butt shown.
They said yes, it is. So,
It's not a bear butt, no. But some of the pictures I can see them over on StreamYard, but I can't really see them till I pull them up. And sometimes I get a surprise. Tomorrow, at some point. Ashley Benefield had a hearing to interview the jury because they claim there have been some shenanigans going on in the jury room. Someone might have been texting, someone might have lied on the jury application. So we're going to watch that hearing tomorrow to find out. Again, please no spoilers for those who watched it. To see, and yes, I know that Karen Reed had her appeal approved, so it'll go in front of the Supreme Court. I am thinking about maybe trying to get Better on for a show if we don't pick up a case in next week talking about the latest and the greatest out of Canton. But no plans made so far. But tomorrow will be Ashley Benefield's hearing to interview the jury, and Tuesday will be me yelling at Sweden because I will be trying to put IKEA furnitures together, and with the wording I'm using, I can't do that live because even Sue will think that's a bit too much.
Yeah.
Thank you, Dream Suburb, for being a member for 2 months. Any pickles in the house? In those? Oh, I thought in the house. I don't know. But join us all on the Discord link in the membership tab. If you don't have the membership tab, reach out to one of the moderators, because in only 3 hours we will have movie night. Jesus, this is later than I thought it would be.
I know, days flying by.
Yeah, I need to go make myself some dinner. Year of the trials 2024. I actually think we've done less trials this year than we did last year because we spent so many weeks on Karen Reed.
Mm.
Yeah, that started in May and went till July. I don't know why I said it. July, like I'm from the south.
Yeah, April to like July.
Yeah. Eddie, been a member for 1 month, and not a Russian. Best bad relationship I've ever had. Well, that's what I say about Jamie all the time. Yeah, and because they have the minigun. I like the minigun. I wish I could shoot the minigun. So, well, I told Nick when I picked up. Oh, I can't even remember, back in March or whatever it was, picked up a case back then and said, Nick, I'm going to do 5 cases before this one ends. I think I have done 5 cases now, and he's still nowhere near the end. Every time I look over at him, it's, oh, the state is going to order 5,000 new witnesses. But that's fun. But go out there, go have a little fun, and I'm going to put you somewhere and give those folks some muffins if you choose to watch them.
Jamie, the talk of the town, dollar store diva, she's holding it down. In thrift shop heels and vintage shine, looking like a million but all on a dime. She don't need a crown or gold to glean, fashion on a budget, living the dream. With every step she's turning heads, slaying the style without breaking.
I'm Jimmy, how y'all doing?
Well,